Good morning, everybody. Depending upon where you are in the world, where I am on the Pacific Coast, it's just 9:30 in the morning. Rebecca, is it 10:30 in the morning there?
It's 10:30 in the morning here. Yes.
Well, great. Today's date is June 5th, 2026. There's been a lot of buzz about this Lego lawsuit, minifigs, all those kinds of things, BAM. And you talked a little bit about this on the newscast last Monday. Today's Friday morning, and through the good graces of an attorney friend of mine who practices in Salt Lake City, I was able to get a copy of the complaint that has now been filed by BAM and the people associated with BAM against everybody else, right? Including Reckless Ben.
Yep. Reckless Ben and the Mancells, right? The family who originally had the Legos. And if I could just say, I'm glad that we're doing this little pop up. Once I heard that you had the complaint, I'm like, I think this is something that people would appreciate you, especially going through. And you're right. We did cover it, the whole scenario very briefly on the newscast. And it was very general, taken from mainstream media. And of course, we had to kind of be a little bit guarded in what we said exactly. In the last week, a lot of things have blown up. There have been redacted videos, that kind of stuff. And a lot of people sent me videos thinking maybe I hadn't seen them because I was so kind of guarded in the way I was presenting things. I had watched most of the videos and I appreciate everybody that sent me videos. I was able to watch more, of course. And I think now more of the story is coming out in a way that our viewers and listeners are aware of in the mainstream. So we can talk maybe a little more freely about that. But, today is not really about the whole story, right? Everybody can go and look that up everywhere through so many different sources. Today is about RFM reading through this complaint of Bricks and Minifigs suit against Reckless Ben and the owners of the Legos. So I have not obviously looked at the suit. I don't think too many people have. So this should be really fascinating, I think.
I got it early this morning, and then I've made my way partially through it, hopefully enough to be able to get the gist of it out there. Now, this is what BAM is complaining about. This is BAM's version of events. I want to make that clear. These are the allegations that they are making. Now, they have filed a lawsuit, and once Reckless Ben and others, but I think Reckless Ben is one of the things that one of the people that has caused the most interest in the case. Once they file their responses to this lawsuit, then I expect we'll be doing a similar thing so we can find out what it is their response is to it. People may be concerned that I'm going over what the complaint is first, just from their point of view. This doesn't mean that I am advocating for that point of view. I'm just saying this is what they are saying happened. This is their version of events.
Right.
Frequently, back when I was in private practice, people would call me, they're charged with a crime. And what I would want to know first is what it was they were charged with. And the reason for that is because a lot of times people want to start telling me a very long story and very involved, and they're usually quite passionate about it. The problem is, I don't know where it's going. I don't know where this is going to end up. And if I can know up front what it is the charge is against you, then I can put everything else into better context. So, similar to that, I want to go over the complaint today, and then I'll be able to understand better what the responses are to the allegations that are being made. Does that make sense?
Yeah, no, it certainly does. We're going to just read through the complaint as BAM and their lawyers have filed it. So this is their version. This is what they are saying about Reckless Ben and the Lego owners.
I know that a lot of people, by the way, here is the complaint, putting it up there on the stage. A lot of people wondering who is representing BAM in this, and are they associated with the church in some way? I can't say whether they're associated with the church in some way or who's paying the bills. I expect BAM has plenty of money to pay for lawyer bills, but at least I can tell you it's not Curtin McConkie. These are the guys who are representing BAM and the plaintiffs. There's William Kelly Nash, Justin T. Rich, Mina S. Gobrial are the attorneys, and they all work for the law firm of Denton's, Durham, Jones, Peiniger. I recognize that last name. PC, and they're located in Lehi, Utah. So there's that. Now, by the way, I also have to add that because of this, I actually had a different interview that was scheduled today that would have been recorded and then released tomorrow, Saturday night, as the regular RFM. Because of this late breaking news, I had to postpone that for a week, so there will be no RFM tomorrow night. My apologies for that in advance. But we will have Mormonism After Dark tonight at 8:00 p.m. Mountain Time. Okay, this is filed in the 4th Judicial District Court. It is filed in Utah, and here's all the plaintiffs. There's BAM Franchising, Ammon McNeff, Matthew McNeff, Josh Johnson, Brandon Best, Baker Bricks LLC, and Salem Baker Bricks. That's the Oregon franchisee of the Baker Bricks LLC, which is the franchisor, I believe, in Utah. All right. And this is who it is against now. It's against Benjamin Paul Schneider, an individual doing business as, and also known as Reckless Ben. This is the YouTuber. Reckless Ben LLC, a California limited liability company. Brian Mansell, an individual. Victor Nguyen, an individual. And I understand that Victor Nguyen is associated with Schneider in some way. Do you want to say anything about these individuals? Actually, let's go through this because we have sort of a cast of characters. In other words, it's going to tell us a little bit about who these different people are. In the next part of the lawsuit, plaintiffs BAM Franchising Inc. Now, when it puts it in parentheses like that and quotation marks, it says BAM, that means that that's how it's going to be referred to throughout this complaint, which is 95 pages long, by the way. I'm going to try and winnow it down a bit.
Wow. And we should say BAM stands for Bricks and Minifigs. I mean, I know most everybody knows that, but maybe there's somebody that doesn't. Or like, what's a BAM? That is the acronym.
Yeah, this is the Lego store. This is
Yes.
the big Lego store in Utah.
Yes.
Ammon McNeff, who will be referred to as Ammon, and Matthew McNeff, who will be referred to as Matthew. Obviously, we can't refer to them by their last names because they both have the same last name. And who are these people, Rebecca?
Yeah, that would be the CEO, Ammon, anyway. And Matthew, you'll have to tell me in the chat because I'm not aware of who Matthew is exactly. But Ammon is the one that's kind of come out in the forefront and, talked defending the company.
Okay. Well, there'll be a little bit more information about it later.
Yeah.
Josh Johnson. Now, my understanding is he is the guy who works for BAM, who went out to Oregon to take over that franchise after the prior owners left. I'll just say left right now.
Yeah. That's a loaded word right there,
Yeah.
isn't it? Yes. Yes, that's correct. And he's the one that appears on most of the footage with the American Fork Police, where Reckless Ben is trying to serve them papers and back and forth. He's on the phone with Ammon during a lot of the newly unredacted video. And so, yeah, his face is kind of in the forefront of all of this because we have video footage and recordings of him, talking to the police and trying not to interact with Reckless Ben.
Is it fair to say that Reckless Ben has pretty much targeted Josh Johnson as the guy that Reckless Ben thinks took these Lego?
I think he's just one of a cast of characters,
Okay.
Yeah, but there is a lot of video evidence from everything that happened back in Oregon. And again, we're not going to delve into all of that, but yes, in this case, he was trying to serve legal papers for an actual case to Josh, and Josh was not accepting them, and the police were not helping to deliver those papers.
Then there's Brandon Best, who will be referred to as Brandon.
Yeah.
Baker Bricks LLC will be referred to as Baker. Doing business as Salem Baker Bricks, Inc., and that'll be Salem Baker. That's the one in Salem, Oregon, right? As opposed to Baker, the main one in Utah. Collectively, all these people are the plaintiffs. Through counsel, file this complaint against defendants. Now, here's the defendants, right? Benjamin Schneider, doing business as, and also known as Reckless Ben. Reckless Ben LLC, Brian Mansell, who will be referred to as Brian. And Brian is the son of the owner of the Lego, the Star Wars Lego that are missing, correct?
Yeah, has really taken point on everything. This
because his
entire
dad is rather elderly, correct?
Yes, and in very poor health, we understand.
So Brian Mansell, Victor Nguyen, and Does 1 through 15, collectively co-defendants. Once again, those are just placeholders in case they come up with anybody else to throw in there. Now it talks about parties, jurisdiction, and venue. This is generally uninteresting, but I'm going to go through it a little bit just because it's helpful because there's so many different players here.
There are.
BAM is the corporation. We've covered that. Principal place of business, Utah County in Utah. Ammon is a Utah resident currently residing in Utah County and an owner and executive officer of BAM. All right. So that's Ammon McNeff, right? Ammon. He's the owner and officer of BAM, executive officer. Matthew is a Utah resident and an owner and executive officer of BAM as well. Ammon and Matthew are referred to collectively as McNeffs. Josh, that's Josh Johnson.
Mm-hmm.
He lives in Utah. He's an owner and executive officer of Baker as well. Brandon is a Utah resident currently residing in Salt Lake County. He's an executive officer of Baker. So all these people employed by Baker. Baker is a Utah limited liability company. It was organized in 2024. Doing business as Salem Baker in Oregon, registered on November 15th, 24. And an authorized franchisee of BAM, engaged in business in the state of Oregon and also doing business in Utah. Upon information and belief, Schneider, that's Reckless Ben, is an individual who resides in or around Los Angeles, who operates under the doing business as Reckless Ben, an online paid streaming content creator and publisher through YouTube, Patreon, etc., who does business throughout the United States and in Utah County, Utah. They have all this stuff about where they live and where they do business because they're trying to establish jurisdiction, i.e., that the court, they filed it in Utah court, that Utah court has jurisdiction over this matter and over the parties. That's why they're putting all this stuff in there. Paragraph 9, Schneider and Reckless Ben, LLC, and their affiliated entities, employees, contractors, etc., including Victor and Yen. See, that's why I said he's associated with them. Along with the Schneider Group's affiliated entities and participants in the enterprise, the Schneider Group. So they're sort of collecting them all together. Conspired together is the allegation from these people. Conspired together and with co-defendants and Crystal Law and Benjamin Gorman, also potential Doe 1 through 15 defendants, and aided and abetted to create, participate in, and effectuated a scheme and enterprise of unlawful activities over a substantial time period through multiple distinct episodes in order to defraud, manipulate, threaten, trespass, extort, injure, and damage plaintiffs, including based on a sustained pattern of unlawful activities, including the racketeering and profiteering and other misconduct described herein, thereby injuring and damaging plaintiffs in Utah County, Utah, and other locations throughout the United States. Co-defendants, they allege, conspired with Crystal and Benjamin to participate in, support, and aid or abet the enterprise and misconduct described herein in or affecting plaintiffs in Utah County, Utah, and other locations throughout the United States. So what they're saying here, the reason that sounds a little bit weird is because even though it's in Oregon that this is happening, they're saying it's affecting us here in Utah. Therefore, it's okay for us to bring this lawsuit here in Utah. It's not just happening in Oregon. The effects of this are not only in Oregon. Upon information and belief, Brian resides in Salem, Oregon, and conspired with co-defendants to participate in the misconduct described herein, thereby injuring and damaging plaintiffs in Utah County, Utah. And then they talk about Victor, who they believe lives in or around Los Angeles and is part of the Schneider Group. I'm not sure he's going to be a big player in this complaint, but they have him listed as a defendant. And they allege that he conspired with co-defendants to participate in the misconduct described herein, thereby injuring and damaging plaintiffs in Utah County, Utah. Does 1 through 15, those placeholders I mentioned, are as yet unidentified co-defendants who conspired with, aided, abetted, and or participated in the misconduct alleged herein, who will be named upon discovery.
So does that mean RFM then Ben has a team, right? He has people
Mhm.
that help him and support him. They'll be looking through discovery
Mhm.
for other people that they believe may have caused harm to BAM and everybody that's listed there.
Yes, exactly.
Okay. So
So
some
these are
people
just
may not
placeholders.
even know they're on this list yet.
Well, they're not on the list.
Right. But I mean, they might not even know that they may at some point be called in and
Yes, I
say,
would presume they don't know that.
right. Okay.
They might be getting an inkling, though. I don't know,
Yeah.
depending upon what they know. So they're alleging the court has jurisdiction over the subject matter and venue is proper in this court, etc. Now, here are the general allegations, okay? BAM is the corporate franchisor of a national Bricks and Minifigs franchise system, which grants private franchises. You can tell private's important to their argument because they're underlining it, which grants private franchises to independent and authorized operators of retail stores throughout the United States, specializing in the purchase, sale, and trade of Lego products, including new, used, and collectible sets and mini figures. So basically, I've read through enough of this to know, and familiar enough with it to know that there's a huge dispute about a massive Star Wars Lego collection being put on consignment at one of the franchisee stores in Oregon. And the allegations in this complaint are that the owners of that franchisee store in Oregon were doing a crappy job and ended up basically bailing on their franchise without any notice. And that somewhere in the process, these Star Wars Lego collection of this elderly gentleman have gone missing.
Yeah,
And the
and
question
again,
is,
the franchise owners have, of course, a different point of view, and everybody can go look all that up. They have their own GoFundMe. They have a different point of view as to how they ended up not being the franchise owners
oh
anymore.
yeah,
But yes, the
absolutely.
Legos, like we said, there's massive amounts of video. I can't even tell you how many hours I've watched. I know RFM has watched. So it's hard to go into every minutia of everything. You guys all know. You guys are all smart. You can fill in the blanks, and if you don't know, you can Google. But we're just adding a little bit of extra commentary as we go through the suit if we feel there's a hole there, but mostly this is what BAM claims. This is
Yeah.
BAM's perspective and their
This
legal team.
is what they're saying to the court as
Right.
well.
Right.
All right. So they're making representations basically under oath to the court, which is different than, I don't know, just saying things on the internet.
Yeah.
Okay. So this is and this is also laying the groundwork for the entire legal case, and that's why it's important. I'm glad you keep bringing this up. People are probably joining who weren't here at the beginning. This is the complaint from the
Mhm.
plaintiffs, BAM and associated people, against Reckless Ben and other people on that side of the V. And what BAM is saying is, hey, we got no idea about this. There was this franchise that went belly up over there in Oregon, and we went in there and took it over, and it was never there when we got there. That's what they're saying.
Yes, and again, you can Google everything around that. But I don't know if you knew RFM, but it looks like perhaps Josh and Brandon were let go, which is interesting. That's a whole
Let
nother
go
level too. Yeah,
from
there's
what?
some from the company.
Hmm.
Yeah,
Now,
so that's kind of interesting
was
too.
Josh Johnson let go from anything else?
Yeah, we can maybe talk about that a little bit later because there
Well,
is
how
the
about
whole
now? Because I'll
Mormon.
forget it
Yeah,
later.
yeah. Well, I mean, there is the whole Mormon, component to this, and people want to know who's a Mormon, right? Are Mormons responsible? This kind of thing. So, I'm often people give me information about who is LDS or who isn't, and of course I did, get information on the different players here,
Hmm.
and just yesterday I got some information that Josh. He even stated on unredacted footage, I'm on the high council, right? So I just wanted to double check that because when
Either way,
somebody's
just so everybody knows, High Council is a leadership group in a stake
right,
in the LDS Church, and a stake is bigger than a ward. It's a
yeah,
collection of wards, and they have a High Council, which is 12 men
hmm
who are under the direction of the stake presidency. So he was one, he claimed to have been at least one of those men who was on the High Council, what we would call a High Counselor.
Right. It sounds higher than it is, doesn't it? When people from outside the church hear high council, they think, ooh, but it's a higher
It's
position
high in the
in
state.
a stake, which is a
Yeah.
group of wards. So yeah, it's somebody, but I never would have thought of it, but he said in the unredacted video when they were talking about somebody coming to his house and he's saying, there is no Harbor Second Ward in this stake. I'm a high counselor. I know. He's
Mm,
right. Harbor Second Ward is not in Josh's stake. It's in the adjacent stake. So that's a little confusing there. But
mhm.
Harbor Second Ward exists. It's in the adjacent stake. But anyway, he said, I'm a high counselor. And so I thought, oh, that's interesting. And I had somebody give me some information that, yes, he was a high counselor from back in fall of 2024, but that he had been released allegedly, according to the information I was given from that position just 3 days ago on the 2nd of June. So I don't know what that means. I don't know, what we can infer from that. And I guess people in that stake, the American Fork Harbor stake, could maybe confirm that. Right now I'm just saying alleged from what I was told, but that would put an interesting twist on it. So somebody else pointed out the Mormon connection. I'd forgotten about this, that Josh and Ammon are mission buddies. So, a lot of things happen. Yeah, spring from the mission, should we say that? Spring from the mission field. So yes, the Mormon connection is huge, and people try to dig around and figure out what it all means, but I'm sure more will come forward. It's interesting.
Basically, it's Josh Johnson cat. The guy went over and took it over that
Yeah,
that franchise in
yeah,
Oregon,
yeah,
and he says, "Hey, they're not here when I got there.
yeah.
That the Star Wars Lego, they weren't here when I got here. Now he's been released from his calling as High Counselor in Utah. Is that correct?"
According to the information I've been giving, it could be alleged. If anybody's in that stake, I guess they could go on member tools. And there are right now 11 high counselors in that stake. So nobody has replaced him, according to the information I was giving, which says, maybe released quickly. And usually people are released on a Sunday. This was not a Sunday. So it's kind of interesting.
No,
Again,
it would
just
have been a Tuesday.
yeah, again,
Right.
just from a source, who knows these things. And I'll just say alleged, but it's an interesting piece to this. Oh my gosh, my brain is spiraling from everything out there, and every day there's something new.
Well, I just wanted to get that fact out of you that
Yeah,
he's been released as a High Counselor
yeah,
for whatever that may mean. The
yeah.
timing does seem interesting.
Strange. Yeah. If true, allegedly, yes, if true.
Okay. But you have high confidence that it's correct, don't you?
Oh, well, I'm never wrong. But
How about just
in
say,
these things, in these matters, I'm
oh,
never
okay,
wrong.
about who holds what callings and
Yes.
doesn't anymore.
Yes,
Okay.
yes. Oh, I'm wrong about lots of things all the time. Yeah, but not about this. But obviously, because I was given the information and, I'm the messenger, I have to say allegedly.
Well, sure.
Yeah.
Okay. Ammon and Matthew are owners, executive officers, and principals of BAM, with Ammon serving as chief executive officer. The McNeffs, with other owners, now that's Ammon and Matthew McNeff, right? Referred to collectively, the McNeffs,
Mhm.
with other owners, have invested substantial time, resources, and capital in developing and protecting the Bricks and Minifigs brand, goodwill, and franchise system throughout the United States. Upon information and belief, now when a complaint says this, it means that we don't have specific evidence for it at this time. We think this is true, and through the discovery process, we hope to confirm this and find evidence of it. Upon information and belief, Schneider and Reckless Bin LLC operate under the online doing business as name of Reckless Bin and including as a YouTuber and content creator with a substantial following on YouTube and related social media platforms, including paid streaming services through or on Patreon, Discord, TikTok, Reddit, and Instagram. Upon information and belief, Schneider and the Schneider Group, Reckless Bin, affiliated and conspired with Brian, Benjamin, and Crystal, who directly and indirectly participated in, supported, aided, and abetted, and or promoted Schneider's content creation, publications, and the alleged misconduct relating to plaintiffs. All right. You ready to go on,
Let
Rebecca?
me ask you one question. So Reckless Ben is in Mexico. He has left after, all of this, and he's in Mexico. And on one of his videos, he said, you'll never find me. I'm here in Mexico. How does this work? Does he need to be served? How do they find him? And, what are the logistics of this?
Very simply, the logistics are that the basic rule is you have to be personally served with the
Ah,
lawsuit.
okay.
And if
Yeah.
it's not by sheriff does that typically,
Yeah,
for a fee.
typically.
That's one of the things that they do, that they have a revenue producer. You got to
Yeah,
pay them to, it's not a huge amount, but they do legal process. They serve legal process when they're not, doing crime.
right.
So that's one way. There's also private service or process
Like a
servers that you
process
can go
server.
to.
Yeah.
However, and you have to try and you have to try and you have to try. And sometimes there will be people on the other side who don't want to be served for obvious
Mhm.
reasons, because a lawsuit cannot proceed until the
Oh,
defendant has received service. I mean,
oh,
you got
that's
to show that
interesting.
they know about it,
Right.
so that if they don't respond within the 20 days of the service, at least 20 days up here, I'm not sure in Utah, maybe a bit longer. In other words, once you're served with a lawsuit, you have a certain period of time in which to file your response to it, your answer. Okay.
Okay. But it can't go forward if you are not served.
Right. Now, if a
That's so
person is
different.
intentionally trying, I'm sorry.
I was gonna say that's so different from the LDS Church. If you remember, my co-host
Oh, yeah.
received letters that he never opened or never indicated that he received, and missed some letters, and yet they still continued with their legal process to excommunicate him without him being there. But in
And
the
that's
real
because
world, you
that's
must be
called due
served.
process. Due
Yeah,
process is meaningless in the Mormon church,
right,
but you have to have due process. Now, on the other hand, of course, the law recognizes that there may be people who don't want to be served,
right.
and you got to keep trying. But if it becomes evident to the court that a person is intentionally avoiding service, then are alternative means that will be accepted as service to the court, which usually involve a publication in a newspaper or newspapers for a certain period of time. And that will be determined or concluded to be effective service. So the law doesn't typically want to reward people who are just hiding out to avoid being served with a lawsuit. So it may come to that. I don't know. But there is a way, even if a person is hiding effectively from service,
Okay.
to have them constructively served. Okay, so here's the private dispute between Crystal and Benjamin. Now, Crystal was initially employed as a BAM owned entity and corporate employee store manager for BAM's then subsidiary, corporate operated Bricks and Minifigs located in Salem, Oregon. So she was an employee at the Salem, Oregon store. During her tenure, she expressed interest in becoming a private, once again, underlined, very important to these people, becoming a private franchisee. That's because they're trying to offload all responsibility on her. During her tenure, she expressed interest in becoming a private franchisee as the owner with her husband, Benjamin. All right, so Crystal and Benjamin go together as the owners of the Salem store of BAMF Salem One LLC. That's called the Salem LLC. That's the store in that they operated in Oregon, Salem. And individually and in purchasing the Salem, Oregon store she managed. BAM agreed to her proposed private franchisee affiliation and purchase transaction within BAM's established franchise agreement structure. So she was able to get a franchise. Pursuant to the terms of a written franchise agreement that was February 6, 2023, that it was dated apparently. It's going to be referred to as the FA, franchise agreement. I'm going to try and remember that and just say franchise agreement. Between BAM and Salem LLC, Crystal and Benjamin, and a business and asset purchase agreement, APA, asset and purchase agreement, between BAM and Crystal and Benjamin. The APA, the asset and purchase agreement, confirmed a closing date of February 2nd, 2023. So this is all happening in February of 2023. It's a little over 3 years ago. In section 4.1, directed that Utah law governed in section 10.3. I think we've all probably signed contracts or something that say that in the event of a dispute, this law, certain state law will govern. I think that's what we have here. So they're saying, our BAM headquarters are in Utah, so that's the law that's going to govern if there's ever any dispute or lawsuit, which is probably also why they're filing it in Utah. And required Crystal and Benjamin to timely pay purchase price installments. So they've got apparently to buy the inventory that's there, royalties and other consideration to obtain landlord consent to a lease assignment for Salem LLC to coordinate account transfers among other obligations for the purchase in sections 2 and 3. You know, Rebecca, you have a career basically in finance. Is that fair to say? So I expect that you understand a lot of these things.
Yeah, well, maybe. Some of them, depending. Franchises are a different beast, and the way that they're set up and the way they're organized. So,
Just for
um,
anybody who doesn't know, you go to a McDonald's store, most of us do from time to time. That's a franchise. So the person who owns the franchise is basically the owner of the store, but he doesn't own it separate and independent from McDonald's. McDonald's allows this to happen, right? And they franchise out their different stores to different people. And it costs, I don't know, what is it, 1 million, 2 million,
it's a
whatever
lot.
it is. It's a lot to buy a franchise
Yeah.
from McDonald's. But then you operate the store, and then you get to keep whatever it is that you get, depending upon how much you have to pay back to McDonald's. All that's in the paperwork, right?
Yeah.
So that's the idea of a franchise.
Yeah, and it's strict. I mean, the paperwork is very strict. Remember, we reported on a cake store here in Utah that was part of a franchise, and the
Oh, yeah.
parent company decided that they wanted all their stores to be open on Sunday because that was a big
Right.
day. And in Utah, they said, well, we own franchises here, but we don't want to do that because our clientele is different and we can't do that. And that's
Mhm.
our religious right. So there's push back and forth between owners and franchise sometimes, but
Oh, yeah.
usually the franchise, it's so ironclad, that they have to do what they're going to say. But I
Well, they
feel like
try
when
to. They
yeah,
try to make it ironclad.
they
Sometimes there's
try
wiggle
to.
room.
Yes. Yes, they try to.
And
So,
and there's no franchise agreement or contract, I believe, that can actually get you out of intentional criminal
yeah.
conduct. In other words, you can't put in a contract, if I steal from you, you agree to let me. I don't think that's considered legally binding, even if
Yeah,
both people
probably
sign it.
not. I don't think
All
it
right.
is. So, and I think we should state again, just in case anybody's joining us, we are reading through the suit, right? These are not the opinions of us here necessarily, right? On the program, we are reading through what BAM is claiming. So, yes, I echo what people are saying in the chat. Watch the videos, Google the story, look at other commentary. This is simply letting you know what BAM is claiming.
Mhm. Yeah. Thank you. Because once again, people are joining all along the
Mhm.
way, and they may not
Right.
have heard that, which has now been said for the third time.
I know it's kind of like what the church is asking John Dehlin to do, right? Every 15 minutes to make some kind of disclaimer. I feel like we need to do that.
This is exactly what it would be
This is
like.
it.
That would be terrible. Okay, so going on. It says significantly, BAM was granted a security interest. So it's significant to them, right? BAM was granted a security interest referenced in APA. That's the asset purchase agreement, I believe.
Yeah. Oh, do you have that up? For some reason, I can't see it anymore. I think you took it
Oh,
down when we were
did I not?
talking.
I didn't put it back up. I
Maybe the
apologize.
audience can see it and
Thank
I
you.
can't. There it is. Okay, perfect.
So, paragraph 22. Significantly, BAM was granted a security interest referenced in the asset and purchase agreement, section 3, and confirmed and assigned to 223 security agreement in and 2. So here they're quoting from it. All accounts, chattel, paper, general intangibles, inventory, and equipment of debtor, Salem LLC, Crystal and Benjamin, whether now owned or hereafter acquired, located, used, or arising in connection with the operation of the Salem LLC. So they have a security agreement. What they're saying is BAM has a security agreement pursuant to the contract in basically everything that they've got at the store. All accounts, their inventory, their equipment. This established BAM's senior claim to and or lien respecting any inventory in accounts and other collateral. Now, of course, we all know that the inventory and accounts that are at play here are the Star Wars Lego set that's missing, and any accounts that may relate to that, i.e., did they get any money for it over there at Salem? And if so, how much? Section 2.3 of the asset purchase agreement similarly directs that the buyer, which is Crystal and Benjamin, shall be responsible for and shall pay all liabilities of the business incurred from and after the closing date. Okay, so when this closes, they've got to pay all liabilities of the business incurred after the closing date, from the closing date. So in other words, it's including the closing date. Lawyers, right? Section 8.2 of the asset purchase agreement mandates that buyer, Crystal and Benjamin, shall indemnify and hold harmless. Okay, this is a standard boilerplate. Shall indemnify and hold harmless the seller. Bam. From and against, and pay or reimburse seller for any and all costs, expenses, losses, damages, and liabilities, including attorney's fees and expenses, suffered by seller, which is BAM, to the extent resulting from, arising out of, or incurred with respect to liabilities of the buyer, arising out of, relating to, or in connection with any claim brought against the buyer, relating to the assets or business operations from and after the closing date. Okay, can you tell why that's in there, Rebecca?
I mean, it seems to say that, the franchisees are going to have to like clean up after themselves when they turn the business over, right? They have to take care of all loose ends. Is that kind of what it's saying? That the corporation would not be responsible?
Yeah, basically they're saying we're doing all this stuff, and if we screw things up or things go missing on our watch,
Right,
then we're the ones who are responsible, and
right,
we're going to hold BAM, the corporate office in Utah, we're going to hold them harmless, and we will indemnify them as well,
right,
and pay or reimburse them. That's BAM,
right.
the seller, for any and all costs, expenses, losses, damages, and liabilities suffered by BAM, the seller. Okay. So that's an important part of the contract that obviously they want to put front and center in their complaint. This is where they're trying to offload the responsibility to the franchisees. Section 8C of the FA. Now, you remember what the FA is, Rebecca?
The FA.
Mm-hmm.
No.
Franchise agreement.
Oh, the franchise agreement. Sorry. There are too
No,
many acronyms in this
yes, there
story.
are.
Oh my gosh. We need a huge whiteboard. I bet some of you guys have this already. Strings and pictures and everything. Every day there's something new.
Now they're going to quote from this of the franchise agreement. Confirm that to preserve the BAM brand, that Crystal, Benjamin, and Salem LLC, that's the two franchisees and the store itself, agreed to only purchase products from BAM. This is another part of their claim, that they agreed in the contract to only purchase products from BAM. In other words, not from somebody else, like on consignment. In pertinent part. Now, can you read this? And if you would just read the
I don't
highlighted part. I know this is the part they want to highlight.
I'm gonna have to like lean way over. Do you want me to
Oh,
read the
can
whole thing
you?
or just the highlight?
Just to highlight it, because what
Okay.
they're going to do is they're going to quote from the franchise agreement about how the people that operate the franchise agree they're only going to buy their stuff from
Okay.
BAM, right? And
Right,
that
right.
kind of makes sense since BAM is giving them the
Yeah.
franchise. But they
No,
don't want BAM
that's
doesn't
important.
want any franchisees to be having other stuff come in that they're selling, okay, which
That's
may do bad things for the BAM product applies in this situation. Yeah,
Okay, I'm
please,
gonna
Rebecca.
lean forward so that I can
Yeah,
see it here. You agree that your store will use and or offer only services, products, and merchandise as set forth in the operations manual or as otherwise approved by us and as may be periodically modified by us
mhm,
in our sole discretion. So you can
right.
basically only do what they say, right?
Well, you agree that your
Yeah,
store will only use the products and merchandise that are set forth in the operations manual. And if it's not in the operations manual, then we have to specifically agree to it. BAM has to specifically agree that you can sell this stuff.
right.
Make sense?
Yeah.
Okay, go ahead and go down there to that next paragraph, if
Okay,
you would.
let's our discretion. Okay, franchise acknowledges
No,
that
franchisee.
franchisees, I
Yeah,
know it's
that's
so
important.
small.
That
It's
extra E is
very
very important here.
The franchisee acknowledges that the franchisee is required to sell and use only approved products, supplies, vendors, and suppliers.
Right.
So,
So in
okay.
other words, once again, they're repeating the same thing
Yeah.
over and over. You can tell a lawyer was involved in this, if not
Right,
many.
right,
So what they're trying to say again is, look, you didn't have any authority from us to be doing anything with consignments or any other
right.
products. And the franchise agreement specifically addresses this issue.
Yeah.
So it's for the operation of the store is also highlighted. And now if you can go to this next bigger one that starts with franchisor, that's BAM, right?
Right, exactly.
One giving the franchise.
The franchisor will provide franchisee with a list of all pre-approved non-Lego brand and Lego So let's say compatible products that the franchisee is authorized to offer and sell in the store. The franchisee agrees that we may periodically and upon written notice add to, modify, or change such approved products, supplies, vendors, and suppliers. Franchisee agrees to promptly accept and implement in the operation of the store all such additions, modifications, and changes at franchisee's expense.
Mm-hmm.
So they have to
Right.
check on every single thing they do, apparently, is what they're claiming that their franchise agreement was.
Well, basically, they're there to sell Lego, right?
Yeah.
Okay, and so this is talking about non-Lego. Now, what we're talking about is Star Wars Lego. So they're not highlighting this for that purpose. They're highlighting this for the purpose about the franchisee agrees and about the written notice that these have to be accepted and implemented by the store from.
Right. And so they're basically just trying to say, you guys never were allowed to do that, right?
Yes.
But of course, then there's other evidence out there that says, yeah, they were totally allowed to do that. So, but we're not weighing in on any of that today. We're simply reading through the claims of BAM.
Right.
So, but there is, other contrary information out there saying, no, it was perfectly fine that they did that. So
this is one side of the story.
Yeah, it'll be up to the
court. We need to understand one side of the story before we can understand the second side of the story. The other side of the story, there's many sides to this story, I think.
Mm-hmm. Yeah, you'll be reading through the other side when it comes out, right? Because there's obviously going to be a counter.
And as an attorney, I'm most interested, of course, in what gets filed in court and what happens there.
Exactly.
So to ensure, could you read this as well? This is another one. It's going to say the same kind of thing, but listen to what it is that they're quoting this for.
I know. I'm sorry I'm reading so slow. I usually read much faster, but I'm like, to ensure the consistent high quality and uniformity of products and services provided by Bricks and Minifigs franchise businesses, franchisees must purchase products, supplies, point of sale systems, computers, software, cash registers, so say camera and security systems, marketing and advertising materials for use in the operation of Bricks and Minifigs from the franchise or affiliate or approved vendors who demonstrate to franchisors continuing satisfaction and ability to, to meet the franchise or standards and specifications. So the franchisee has to have everything looking uniform, right? Like McDonald's, you can't start making your own special burger. This is cool. Grandma's special burger. You can't throw that into your franchise.
Can you imagine if an owner of a franchise started advertising their husband's hot dogs?
Yeah, exactly. That's what I'm saying. Or a special hot sauce. Yeah, you're not allowed to do that at all.
So this is all very standard stuff.
Yep.
It's just when things hit the fan that all of a sudden now it becomes important, right?
Yep.
Okay.
Every minutia. Yep.
Now they say, to be clear, APA, Asset Purchase Agreement. These are the two main documents that they entered into in order to sell this franchise. To be clear, APA Section 1 provided that while select consignment services may be permitted, this is going to be an issue, obviously. Now, notice how they actually reproduce and highlight this franchise agreement that you just been reading, Rebecca. Are you there?
Yeah.
Okay.
Can you not see me anymore?
I'm reading this. Anyway, to be clear, APA Section 1 provided that while select consignment services may be permitted. Notice they're not going to reproduce this. Okay.
Yeah, that is interesting. Everything else was reproduced, but this isn't.
Yeah, so I wonder about that. Anyway.
I do too.
Provided that while select consignment services may be permitted, such were limited expressly to those approved by BAM. BAM, once again, in brackets, which means it doesn't say BAM there. It may say the whole thing. I don't know. APA Section 18A mandates all modifications to this agreement must be in writing, signed by both parties. So what they're saying, what BAM is saying, is that even though the asset purchase agreement does provide that consignment services may be permitted, they have to be approved by BAM.
Yeah.
And these were not. Okay. That's what they're saying. But apparently there is language about consignment services in the APA. So here's what they do reproduce. Whenever this agreement requires the approval or consent of either party, the other party shall make written requests, therefore, and this approval or consent shall be obtained in writing. All right. So they're saying, look, You could have done a consignment service, but we would have had to have approved. It has to be done in writing. There's no writing because we didn't approve it. So what they're going to be arguing is that the franchisees are operating outside the scope of their franchise agreement, and therefore they're responsible, not us.
Exactly. This is what BAM is claiming.
Despite the foregoing plain requirements, Crystal and Benjamin, the operators of that Oregon franchise, materially breached their obligations. As required, APA, asset protection, agreement. Payments. So the payments required by the asset purchase agreement, were not completed, they're alleging. Franchise agreement royalty payments became delinquent. The lease and various accounts were never properly transferred, and lease amounts were unpaid. Crystal's outstanding contractual obligations mounted, eventually exceeding an estimated $175,000. So they're saying she was doing a crap job over there in Salem with her husband, and
Yeah,
they're
this
not
is their
paying all the stuff that
claim.
they're supposed to pay. What?
Right. This is their claim again. This is their
Yeah.
claim. This is what BAM is saying.
In early fall of 2024, Benjamin accepted work overseas, and Crystal advised BAM that she intended to close the store and abandon the franchise operation altogether, including stating an effective date for such closure of December 2024. As she did not have the right to do so under the franchise agreement, to just up and close it apparently, BAM notified her that such was not appropriate. Based on the foregoing uncured breaches and anticipatory repudiation, so in other words, uncured breaches, she's been in breach of the contract. They say it's up to $175,000. Those are the uncured breaches. If she had paid it, it would have been cured.
Right.
And anticipatory repudiation, we expect her to repudiate the contract. In other words, they're going to violate the contract. And they figure it's anticipatory because she hasn't done it yet, because she gave them the date of December 2024 when she was going to close. So BAM, inter alia, based on that, issued a written notice of immediate termination to Salem LLC, the store, pursuant to the franchise agreement that was written on November 14th, 2024. BAM exercised its priority rights to the collateral in the security agreement. So remember, it established they got a priority right in whatever inventory you have and anything that's in your accounts. So they're going to exercise that. It's ours now. And they pre-scheduled a repossession. It's not just for cars anymore. Pre-scheduled a repossession with Crystal and repossessed the Salem LLC store on or after November 14th, 2024, and assumed the lease. So they're taking the lease over again, as expressly permitted under the franchise agreement and asset purchase agreement, including any and all fixtures, inventory, and other assets. And they credited an estimated $38,000 paltry value thereof as an offset to the unpaid $175,000 debt. So based upon the inventory and stuff that they had, they gave that a $38,000 value. So they're taking over $38,000 of inventory that was owned by the franchisees, Crystal, right? And they're taking that, valuing it, and then offsetting it against the unpaid $175,000 debt that they claim that Crystal owes them.
Yeah, and that is it. They claim, because as we know in the chat, and we know from watching all the videos, there's a lot of other information out there from the franchisee's point of view that this is not what happened. So it'll be really interesting to see this play out in court, because there's a lot, right? But again, we're just reading through BAM's claims. It does not represent our point of view necessarily. We are reading through the claims. So
is that 4 times?
I think I had to do it 4 times.
You have to keep track of this.
I'm just addressing the chat, because people come in late and they're like, watch the videos, you don't know. And I'm like, We do know.
Everybody
We're
in the
reading
live
through
chat, would you
Bam's
please let
claim.
people know who come in late what's going on here? Otherwise, we're
Exactly.
never going to get through this.
We're never going to get through it. That's right. We're aware of all the contrary evidence to all of this. So it's very interesting to read through and try to anticipate how this is going to shake out in court. It's going to be fascinating.
Accepting only respecting the foregoing unpaid lease, BAM did so as a bona fide purchaser without notice of any third-party claims or liens of any kind, including Crystal and Benjamin's undisclosed and alleged 11/22/23 consignment agreement with Brian, referenced infra, and infra means in this, elsewhere in this complaint, infra. All right. Now, when they say that BAM took over the inventory and assigned a value and offset it against the debt that they claim that Crystal owes to them, whatever inventory there was, they bought as, and they're saying they bought it by offsetting the value against the debt, right? That they purchased it as a bona fide purchaser in good faith. Now, what this means, I remember this is from contract law. A bona fide purchaser in good faith, which means that if you really if you buy something from somebody and you buy it legitimately and you believe it's going to end up being stolen, okay? That's where this is leading to. But there are circumstances in which you can legitimately buy something that's been stolen. You can't legitimately buy something if you know it's stolen. You can't legitimately buy something if it's bought from the person who stole it, if you have a good reason to believe it's stolen or if you know it's stolen. But if you buy something in the regular course of commerce and you are a bona fide purchaser in good faith, that's why that means so much in contract law. Then even if you end up buying something that is stolen, then the person from whom it was stolen doesn't get to go against you in a lawsuit to get it back. They can go against the person who stole it, right?
Right.
But if it's down the chain to a bona fide purchaser in good faith, then that's a defense. And that's why they're stating it here. They're claiming that BAM is a bona fide purchaser. Okay. Does that make sense?
That does make sense. Yeah. But
And
again, a regular person wouldn't know that, right? This is why we need you to read through this. It's so interesting what they're claiming.
And here they're referencing in this little paragraph 28 also this consignment agreement, which what they're saying was undisclosed, and they're saying it's alleged. Okay. November 22nd, 2023 consignment agreement with Brian. Okay. And Brian is he's the son of the man. We might as well just say he's the guy with the Star Wars Lego set, right?
Yeah. Just say the Lego owner. Yeah.
Yeah, because his dad doesn't really show up in here. And he's the one who's the defendant. Prior to and at the time of repossession, that's when they went back to the store and took it over again, BAM's representative, Brandon, conducted an informal and video inventory of the Salem LLC fixtures and inventory. While he did not locate or identify any product that was identified as consigned or not owned by Salem LLC, he concluded that the maximum value of any residual inventory was less than $38,000. All right. So any inventory in the store, $38,000. And of that $38,000, if he just looked, this is the claim. If Brandon looks at the Star Wars Lego products, there was less than $5,000 worth of Star Wars Lego products. And of course, that's what we're interested in because it was all Star Wars Lego. That's the issue here. That's missing. Less than $5,000 worth of Star Wars Lego product could be located and identified in the entire residual Salem LLC on-site inventory. Incident thereto, BAM requested access to and that copies of all relevant business records be provided by Salem LLC, which Crystal and or Benjamin refused to provide, including inventory reports, agreements, financial statements, etc. Undisclosed and unauthorized 11/22/23 consignment agreement. So now we're getting to the Star Wars Lego set at issue. Upon information and belief, during her tenure as a franchisee, on or about November 22nd, 2023, Crystal entered into an undisclosed and unauthorized, they say, private underlined consignment arrangement with Brian or his aging father, Eric, allegedly relating to an inventory of alleged Lego collectible sets. A purported but unsigned, written November 22nd, 2023, same date, consignment agreement is attached as Exhibit A, which is between Brian Mansell, the Star Wars Lego owner, and Bricks Minifigs, Salem/Kaiser, at this address in Oregon. In other words, that store, and they call it Bricks. Plaintiffs do not have a copy of a signed version, though Brian has alleged it was signed by Crystal and Brian, which would make sense that they would both sign it.
Mm-hmm.
But what BAM is saying is we don't have a copy of the signed version, just an unsigned version. So this is just a complaint. They're going to try and find that through discovery later on.
Yep.
At that time, and until the present, Bricks was not and has never been a known or legally registered entity. And in any event, Bricks is not Salem LLC, leaving Crystal personally liable for the terms of the 11/22/23 consignment agreement. So I think what they're trying to say here is that they use the wrong name. Crystal uses the wrong name to sign, though they don't have a signed agreement. They use the name Bricks, which is not the legal name. So I think that what their allegation is, because it's between Bricks and Brian, and Bricks is not associated with BAM, that Crystal is now going to be personally liable for this.
I have to say, I pity the judge who has to hear this.
Let me tell you something.
Going to have to go through hours and hours of video. It's exhausting, and there's something new all the time.
The judge is not going to have to go through hours and hours of video. The judge, unless it is submitted.
That's what I meant. I'm
Yeah,
sure
and in
they'll
fact, it would
submit
be
it.
improper for the judge to go through hours and hours of
Oh,
video
yeah.
to look at
No, on
things that are
social
outside
media.
the case, right?
Yeah, of course. But I'm sure that each side, I mean, I'm sure that Reckless Ben's side will be submitting, there's so much video evidence out there and photographic evidence that I'm sure they'll be submitting that.
I would imagine. So if it is relevant to the case.
Right.
And it sounds like it might be.
Yeah.
Importantly, in the purported consignment agreement, Section 5, Crystal agreed and warranted that she, quote, has purchased insurance sufficient to cover the loss or damage of the Star Wars Legos, and agreed to store the Star Wars Legos in a manner customary in the industry to prevent damage, acknowledging she shall be responsible for all shortages, loss, or damage to Star Wars Legos while in her control. So even though it's not signed, that's the consignment agreement that they're quoting from that BAM says they have. 34, regarding the arrangement and storage, Brian has described the arrangement as follows. Now, do you think you could read this? This is from Brian.
Okay. Starting at when?
Yes.
Okay. When Eric Mansell, that's
his dad, right?
Older man, yes,
Yeah.
decided it was time to divest, he turned to his son, Brian Mansell. Brian knows more about his father's comic book and baseball card collection, but didn't feel confident in his knowledge of the Legos, the secondary Lego market. He saw the sign for Bricks and Minifigs store while passing by on a North River road, came in and asked the store owner, Crystal Law, if she could help. Crystal told him, even if we couldn't sell the collection, I would help him figure out how much it was worth because I didn't want him to get ripped off. And I think that's why he trusted me, Law said. The entire collection will be sold through Law's store, but first they wanted to put it all on display so the public can see it in its entirety.
So
Pretty
this was
impressive.
a huge deal.
Yep.
They're trying to even use it for advertising, I think.
Oh, yeah. Who wouldn't stop by to see this massive collection of I wish I would have not unboxed my Star Wars Legos. I bought so many for my kids, and
Really?
they're probably all down the heater vent at this point. But yeah, if only I would have purchased it and said, okay, this is yours for Christmas, but we're not going to take it out of the box.
Right.
We're not going to play with it. We're going to put it over here. If only I'd done that. Dang it.
Yes, and then you could have maybe consigned it to this store and lost it all.
It could be me. I could be in this too.
Then there's a second paragraph there. That's from the same statement that they're saying it's from Brian Mansell.
Let's see.
The
Okay.
collection will be on
The
display.
collection will be on display in the store's party room from 10 a.m. until 6 p.m. on Saturday, November 11th, and 11 a.m. till 6 p.m. on Sunday. The collection will be available for sale immediately. So the best time for pictures will be Saturday morning. The collection will not be stored on site after hours, and that is underlined for security reasons. And after Sunday, the sets will be available for purchase but stored elsewhere. Also underlined, they're trying to make that clear. Bricks and Minifigs is located, and then it gives the address there on River Road in Kaiser.
Right.
So it was promotional. The party room, you can take your kids in and ooh and ah over this huge collection, but it's going to be sold and it's not stored on the premises, according to this.
So they say they're quoting from an informal transcript of an April 16th, 2025 collecting weekly YouTube video. Okay. And they give the reference at minutes 44 to 45. You can look at that yourself if you're watching the show, and look it up if you like. There's the whole reference. He says, they say it's referenced but not shown by Schneider, Reckless Ben, in his 5/21/26 YouTube video defined below as included in publications, and posted on Facebook by Crystal at Salem LLC. Notably, Crystal confirmed that the collection was not to be stored at the Salem LLC store. Yes, we got it when you underlined it both times. Yes, notably, they want to stress that.
Yeah.
Upon information and belief, Brian and or Crystal initially valued the alleged consignment collection in the range of $80,000. Once again, upon information and belief, which was later reduced by its cost value of $30,000 or less to $60,000. So this is what they're saying is nowhere near the allegations that I've been hearing in the press about the value of it. What have you heard about the value of the Star Wars Lego set?
Yeah, they see 200,000 to 250,000 is what I see in most of the media and the videos. So, and then interestingly, the GoFundMe is up over 300,000 at this point. I think it's up that high. So that's kind of interesting. It seems like, I don't know, comparatively to all of this, a small sum, but it's not. It's like the principle behind it, right? And I think that's why it's so intriguing to people. You know, it's David and Goliath kind of a story.
Well, those Star Wars Lego went somewhere.
Yeah, they did go somewhere. Yep.
And everybody's saying
and not to Ben's Airbnb, right? Not there.
As noted above, the proposed consignment arrangement, which was not expressly approved by BAM, can't say that enough, is not permitted under BAM franchise standards. And this private arrangement was entered into solely by Brian and Crystal in an unauthorized capacity, and not on behalf of BAM or Baker Salem, which had no knowledge of or involvement regarding such. We didn't know anything about this, they're saying.
Right.
Upon information and belief, Crystal or Salem LLC sold part of the consigned inventory and paid Brian for such. Salem LLC or Crystal had ample time to sell the consigned inventory during the approximately 1 year period prior to Crystal's abandonment of the store. And they say, and did so. Of course, it's upon information and belief. Such sales activities have never been reported to or accounted for with BAM. Okay, so chronologically speaking, I think it's pretty much a year. I think it was it November of 20, hang on a second here. It was November of 23 that the consignment agreement was entered into.
Right.
Between the Mansells and Crystal at the Salem LLC store. That's November of 23. And it was November of 24 when Crystal says, hey, we're bugging out. We're closing. We're dropping the franchise and leaving.
Yeah. And again, that's BAM's version of it. We all know, we've seen other to the contrary. That's a whole story in itself. So, but BAM's just saying they just decided to go. Yeah. I wonder why.
And for those of you out there who have information different, that's great, because that's what this is all going to be tested against. These are the allegations. These are what BAM is claiming is true. So anything you find that's not consistent with that is great. Well, if you're not BAM.
Well, no, and that's why I think it's so intriguing is that there is so much, video and photographic evidence that is
Mhm.
not following this line here. And so, even a layperson in their armchair can go, wait a minute. And that's, I think, why it's so intriguing to so many.
So now we're back to paragraph 37, which talked about that year-long time. They're saying she had a year to sell this stuff. If they entered into a contract to sell this stuff, she had a year to do it. And she probably did, what they're saying. Crystal failed and refused to pay Brian monies that may have been due to him under the consignment agreement. As noted, on or about November 8th, 2024, Crystal informed BAM corporate leadership that her partner had accepted employment overseas and that she intended to close the store, and she thereafter abandoned the store in connection therewith. BAM advised her that a closure was not permitted under the franchise agreement, including due to her unpaid royalties, defaulted asset purchase payments, and outstanding contractual obligations.
Yeah. Again, that's highly disputable, but that is something that a judge is going to have to look at.
Oh, yeah. This is going to be a very paperwork intensive case.
Yeah, it really is.
One would think that BAM should not be making these allegations unless the paperwork is going to support them, but stranger
Yeah.
things have happened, I suppose.
Exactly. And I think that's why people are like, wait a minute, we've seen this and that does not
Mhm.
support that at all. So, but again, this will all come out in court.
Yeah, nothing is better than getting a complaint when you already know that the person is not telling the truth.
Yeah.
In other words, you usually have to go investigate thereafter, but coming into this, many people may have evidence that they feel contradicts this.
Right.
BAM thereafter notified Crystal that it would repossess the store pursuant to BAM's preserved rights regarding such under the franchise agreement. When BAM representatives arrived for the scheduled turnover on or about 11/14/24, Crystal became uncooperative and interfered with the agreed smooth transition and refused to provide records and remove certain receipts. So they're alleging that Crystal not only
Mhm.
refused to provide records, that she
Yeah.
removed certain receipts and that she removed a high-value Boba Fett minifig
Yeah.
and possibly money in the safe over Brandon's objection. Brandon being
Yeah.
the guy from corporate who's going there to do the inventory. And ultimately, I think to take over the store, but we're not there yet, along with Josh. And ultimately was escorted out of the store. The store was empty, looked unpresentable, and had been ransacked, they allege. As noted, BAM issued its 11/14/24 notice of immediate termination and assumed possession of the premises and all assets located within the store as part of lawful recovery actions. Brandon was engaged as a contracted inventory inspector for BAM and was requested to inspect and inventory the Salem LLC store at the time of repossession. After Brandon secured the location incident to the termination and completed the inventory, Josh Johnson, expressed to BAM his interest in acquiring a franchise for the store location. So Josh, already working for BAM, I believe, says he wants to run the store. He wants to get the franchise for the Oregon store. Josh later inquired if Brandon would be interested in participating in such an acquisition, and they agreed to jointly do so. And they formed Baker Salem. So that Salem LLC, that's the name of the store when it was being run by Crystal and her husband. Now they form it into Baker Salem. That's the name of the store when it's being run by Josh and Brandon. If you didn't think it was confusing enough already.
Yeah. And again, I have to say there are pictures with timestamps of the Legos in the store, so this kind of evidence, you wonder what BAM has that they think could counter what everybody else in the whole world has already seen. It's just going to be so interesting to watch this.
Mm. So Josh and Brandon, believing they could purchase the assets free and clear, assume the lease from BAM, and infuse new inventory into the rundown location and make it successful, after Crystal had run it into the ground. BAM's bona fide repossession and acquisition of secured assets and lease. So now they're going to say, once again, we're a bona fide repossessor. We're a bona fide purchaser.
Right.
As we go in there, we repossess this with all the inventory, and we're doing it in a bona fide way as a bona fide purchaser in good faith. In other words, you're saying if any of that inventory in there was from some kind of consignment agreement, what they're saying is we didn't know anything about it. Following its lawful termination for cause and repossession, BAM acquired the store's assets as a bona fide purchaser for value without actual or constructive notice of any actual third-party right, claim, or lien, and given Salem LLC and Crystal's breaches, including the undisclosed private consignment arrangement without notice to or the consent of BAM. Is all this making sense so far?
Yeah, it does make sense.
As Crystal, Benjamin, and or Salem LLC's purported and undisclosed consignment arrangement with Brian was entered into in an unauthorized capacity. I want to make sure you understand that.
Authorized.
And was never disclosed to or approved by BAM. BAM took possession free of any claims or liens. So this is another one of their defenses. I would say it's their primary defense. In or about the first quarter of 2025, so that was November, now it's the first quarter of the next year, Josh and Brandon agreed to clean up, manage, and operate the BAM repossessed store in Salem, which was subsequently sold and transferred along with the store's assets to Baker Salem. Remember, that's the name of the new store owned by Josh and Brandon.
I'm telling you, you need a whiteboard.
And a lot of yarn and push pins.
And a lot of yarn and thumbtacks. Yeah.
These parties did so without actual knowledge of Brian's purported consignment claim. So they're asserting the same defense for them as for BAM itself, which is why they can be represented, all of them, by the same law firm and lawyers, because their interests are aligned. They don't have a conflict of interest, at least not at this point. And any such claim, to the extent it existed, which was subordinate to BAM's security interest and the sole responsibility of Crystal, Benjamin, and or Salem LLC, their store. Baker Salem's bona fide acquisition of assets from BAM. We cannot say this enough in this complaint. In the first quarter of 2025, BAM completed the sale to Baker Salem, Josh and Brandon, who became new franchisees. And in connection therewith, they, through and in the DBA, doing business as, of Baker Bricks LLC, entered into a franchise agreement with BAM. So they're going to enter a franchise agreement. It's January 9th, 2025. On March 27th, 2025, BAM finalized a business and asset purchase agreement, their APA, with Baker. And they're going to say Baker, and that's the name of the new store. Okay. Baker did not at any time acquire, take over, or assume any obligations of Crystal or Salem LLC, the former store, on the same site. These bona fide third-party purchasers were not involved in the prior private dispute between Crystal and Brian, and except as noted regarding the inspection by Brandon, they acquired the business from BAM pursuant to an arm's length and legitimate corporate sale and transfer, and began operating as an independent authorized franchisee of BAM. Now, I know they're going to want to say it's arm's length and legitimate. And maybe it was, I don't know. That's what they're saying. But I do have to note that both of these individuals were kind of high ranking in the leadership of BAM before they took over that store. So the question of it being arm's length becomes more of a question under the circumstances. That's all I'm saying. Does that make sense to you?
Yeah.
I mean, they're very close. So how arm's length was it when they gave the franchise to these two guys to go operate that store? Brian demands return of allegedly consigned Lego product, and they say without evidence. Okay. So here's Brian Mansell. Within 24 to 48 hours following Crystal's termination in late November 2024, Brian called the store and asked for Crystal. Brandon answered and explained Crystal and Salem LLC had abandoned the store and were no longer involved. Brian claimed he had a consignment arrangement of some sort with Crystal, I think that one got misspelled, and Salem LLC, and stated she had not paid him monies that were due from sales. Josh and Brandon were skeptical, and Brandon explained the need for evidence of any ownership claim he may have. Brian showed up later that day. Can you imagine being Brian under the circumstances? Brian showed up later that day and began yelling at personnel and holding up purported consignment paperwork, demanding the immediate return thereof or payment of $80,000. Josh interceded and asked to review it, and briefly did so, and pointed out that neither Bam nor Josh and Brandon were a party to this purported arrangement. As he claimed he had a purported inventory list, Brandon and Josh invited him to review the limited number of Lego sets on display, which were in Bam's corporate-owned store at that time. When Brian could not identify any Lego sets on his purported list, he accused Josh of lying and was told to leave. He left in anger. I mean, you know, from Brian's point of view, not to mention his dad, Eric, here you've got a very valuable Lego collection. It's been collected over a long time. Finally, you want to sell it. That's a difficult decision to make. I can tell as a guy who sold his comic book collection over 1,000 comic books and still regret it to this day. And you do a consignment agreement with a local store, which I guess you picked because you saw it driving by, but still. And then it's a year later. I don't know what success you've been having. Maybe some, maybe none, maybe, but not all. And you call up to talk to the person you've been dealing with, and now there's somebody new on the phone, and you find out that that other person doesn't own the store anymore, and it's not even named the same thing anymore. And you go down there, and they say, well, this is everything that's here, and you look it over, and your Lego sets aren't there.
No, that's horrifying. That's a horrifying scenario.
Yeah, it is. Brian's purported inventory list, which he later provided Josh and Brandon in or after May 2025, was problematic in that it was not complete and did not have value data for every listed item. And when I read that, it means it had value data for some listed items, right? And they're saying it's not complete. I'm not exactly sure in what way, but they're saying he came back with it, what, in May? So that's after November when he came into the store. About 6 months later, they're saying. Brandon briefly investigated whether any consignment product might exist in boxes in the back or elsewhere in the store and concluded none existed, as confirmed by 2 staff personnel who had previously worked for Crystal. Brian returned later that evening after closing with the police and accused Josh and Brandon of theft, which they denied. Josh and Brandon informed the police that Bam had recently repossessed the store and that they were unaware of and not parties to any consignment agreement and did not knowingly possess any of his alleged property. When Brian became belligerent, he was escorted off the premises by the police officer who concluded this was a private civil matter. It's a civil matter. And Brian had insufficient evidence of ownership. Well, it doesn't make any difference what the police say. All they're saying is they're not going to do anything about it as far as criminal charges. They've labeled it a civil matter, which means they're kind of off the hook. This is one of the favorite things that police have to say to people, so they don't have to investigate something. It's a civil matter.
Oh, yeah, we wash our hands. This is a civil matter. But can you imagine, Brian? Oh, I mean, seriously, that feeling where you're told, no, we can't do anything. We don't know where they are, and you have no leg to stand on. No wonder he turned to social media.
What they're saying is you have to get an attorney and file a lawsuit.
Right.
It's a civil matter, in other words, right? So, but that lets the police off the hook of investigation as well. And I'm not saying they didn't think it was a civil matter. It probably is a civil matter, but still.
Yeah.
And this is a civil matter. It's a civil complaint we're reading.
Yep.
Thereafter, and for a period of months, Brian directly and indirectly harassed Josh and Brandon and the personnel at Baker Salem, made threats of physical injury to their employees, including an in-person death threat to the store manager, lodged police complaints, posted negative reviews, and incited others to negatively post online comments, contacted a podcast, Reckless Ben, I imagine, which later led to Schneider's involvement.
Yeah, it was initially a different podcast,
Right.
and then they were looking for some story to do that was more wholesome, so it didn't get taken down. Some of the things he covers are kinda dicey, and, Lego is so wholesome, and then who knew? Who knew that this is what would happen from that?
Hmm. They continue with their allegations. Josh and Brandon reported these incidents to the police, who cautioned care but did not charge Brian for unknown reasons. Okay, well, they figured it was a civil matter, right? So, in other words, if they think it's a civil matter up here, then and that's and they're right, right? Because they're saying the police were right that this is a civil matter, this whole thing. But then they express bewilderment that the police figured it was a civil matter what was going on with Brian. So police says he hasn't crossed any lines, apparently, legal lines as far as criminal law.
Right.
Upon information and belief, Brian, and by the way, I don't know. If there was really an in-person death threat to a store manager, I think the police would have done something. Upon information and belief, I should put that differently. If the police felt there was evidence that there was really a death threat, they probably would have done something. Upon information and belief, Brian attempted to obtain payment from Salem LLC, Crystal and Benjamin, but such were unsuccessful, as Crystal claimed she had no money to pay him for sales of any alleged consigned product. So they're saying that they think Brian also went to Crystal and Benjamin and tried to get his money from them. Not successful. Many months later, in the fall of 2025, and only after Baker Salem had entered its 3/27/25 business and asset purchase agreement, Brandon gained access to Salem LLC's archived and incomplete point of sale accounting system, which he discovered identified Star Wars lot sets from Star Wars regular lots inventory sales. This inventory sale distinction was unclear to Brandon and Josh, and Crystal had never explained the significance, if any, to anyone. But Brandon, much later in 2026, discovered that approximately 367 purchases of lot sets, and I'm wondering if that means like packages,
Mhm.
for an estimated retail value of $46,000, and 336 purchase of lots for an estimated retail value of $12,600 had occurred after 2023, which is when I think Crystal and Benjamin got the store. He still could not, however, confirm the specific products sold and whether they had been consigned or not. A copy of this informal audit and recent discovery, including the purported inventory list provided by Brian in or after May of 2025, is attached as Exhibit B. I think before this case goes too much further, they're probably going to have to do a forensic accounting of that, not just have this informal audit by one of the parties. But that's up to them. Upon information and belief as illustrated in Exhibit B, Josh and or Brandon's informal audit and recent discovery show that Star Wars products similar to those same sets, allegedly consigned by Brian, were virtually all sold prior to December 2024 by Crystal or Salem LLC, suggesting very few of the alleged consigned product existed thereafter, as Crystal had sold virtually all of it. To the extent she effectuated such sales, it appears she may not have compensated Brian for such or provided him with any accounting giving rise to their private legal dispute. So if it's not clear, what they're saying is, yeah, she got the consignments. Apparently, it looks like these may be the consignments. She sold practically all of it. And if she didn't pay Brian for it, then that's between Crystal and Brian.
Right, that's what they're claiming.
Yeah. And they're claiming to have evidence of it.
They're claiming to have evidence. That's why I think we're all so curious, because we've seen, we've seen contrary information. So it's a he said, she said.
Yeah, it's becoming a he said, she said, they said.
Yeah,
and these
everybody
other
said.
people said. Conspiracy and formation of enterprise to engage in unlawful activities. This is the title of this part. Upon information and belief, though they had no legitimate legal recourse or evidence upon which to file a claim, Crystal, Benjamin, and Brian conspired to. So he's putting the former owners of the store together with Brian, the seller of the Star Wars Lego set, together in a conspiracy.
Sorry, I had to let my dog out
Okay.
of my studio. Yeah. No, this is all it. Wow.
They're saying Crystal, Benjamin, and Brian conspired to inter alia, which means, among other things, threaten, intimidate, extort, and defraud plaintiffs any way possible, as detailed herein, including the formation of an enterprise to engage in wrongful activities. As an initial step, Salem LLC caused a 12/24/24 legal demand letter to be sent to BAM, variously alleging it had been damaged based on the termination of its franchise agreement. So this is right after it's been terminated, right? She's been issued or escorted out of the store, all the stuff we read about earlier. And then a legal demand letter is sent to BAM later that month in December of 24, saying it had been damaged, the store had been damaged based on the termination of its franchise agreement, which was a private business matter between Crystal and Salem LLC. On 1/10/25, BAM responded denying the allegations and providing support for its termination. Neither Salem LLC nor Crystal or Benjamin thereafter pursued any claim in the letter further with BAM until 1/2/26, so that's a year later, when a separate legal demand letter was sent as discussed in for. By the way, legal demand letter, it's a letter. It's not a lawsuit. Usually it's threatening some kind of legal action if you don't comply, but it's really just worth the paper it's written on as far as any need to respond. But they responded, and then apparently they didn't do anything about filing a lawsuit, is what they're saying. And then a year later, on January 2nd of this year, 2026, a separate legal demand letter was sent, as discussed infra below.
Can I ask
Instead,
another question?
Yeah.
I mean, it seems like there are just two separate scenarios here. We, of course, at the beginning of the suit are covering, what's going on with Crystal. And then obviously we'll move into Ben. But is that typical that you sue people together, even though it's so different what they're claiming from each person? Why wouldn't there be a separate suit against, Crystal, a separate suit against Ben's team? Does that make sense?
No, not at all.
Not at all.
I mean, it might to you. It might to you.
Yeah, no, it seems like everything's so different. Like
You
the
want to put all
evidence
your
is
claims in
completely
one
different.
basket.
Everything
As
together.
hard as you can. Now, it's possible that Ben could come forward and say, look, you should sever me as a defendant.
That's what I think. He has nothing to do with this. He wasn't even involved yet,
No, he has
page
nothing
after
to do with
page
this
after
part.
page.
They will get to his
This
involvement.
Right. That's what
Yeah.
I'm saying. That just seems to me strange that they would all be lumped together into this one where Ben hasn't even entered the scene yet and really has nothing to do with Crystal whatsoever.
Correct. So if Ben wants to, he can make a motion to sever himself as a defendant.
Mm-hmm.
And then the judge has to make a determination. And if I recall correctly, the legal standard has something to do with, well, I mean, are you really substantially a part of this case? Or is the evidence, in other words, looking forward to trial, all right? Is the evidence such that it's basically we're going to have to reproduce the same evidence in both cases if we were to sever defendants? And if we do, to the extent that that is more likely that we're going to have to reproduce the evidence in both cases, then it's more likely they will not be severed and they'll continue as one case.
Yeah, I mean, he's showing videos and photographs and giving commentary on, what they're claiming here, in the first part of the suit, but he was not even on the scene yet. So maybe that's how it ties together. It just struck me as strange. It just seems like has nothing to do with one another.
Well, on the other hand, it really has everything to do with one another, doesn't it? I mean, how can you understand? It's tough enough to understand just this part.
Right. How
How
can you understand what Ben did? Right. Without understanding what happened with Crystal.
You would have to prove all this stuff all over again.
Right. I guess that makes sense.
Okay. So I think that's why. Although, once again, a defendant can make a motion to sever.
Right. I'm trying to ask the layman's question. The
And I'm glad you are.
layman's question, right? What makes common sense to us. A lawyer will go, oh, no, that would never happen. And we're like, okay.
And it could, but I'm just saying that it makes sense to me that they would be included.
Right.
Instead, upon information and belief, Okay, wait a second. That's that separate legal demand letter sent a year later, January 2nd, 2026. Instead, upon information and belief and in furtherance of such threats, Crystal, Benjamin, and or Brian learned of Schneider, Reckless Ben, and communicated with him, whereby they provided information regarding their unsupported claims against Baker, Salem, and or BAM, ignoring and excluding Salem LLC and or Crystal's sole obligation regarding any private consignment agreement with Brian. In connection therewith, they, together with others, i.e. Does 1 through 15, conspired to intentionally, maliciously, fraudulently, and illegally threaten, extort, harass, profiteer, interfere with, and damage plaintiffs in furtherance of the enterprise. So the enterprise is not a starship here. The enterprise is this conspiracy that they're alleging. They're giving it a name, the enterprise, including based on the unlawful activities described herein. Upon information and belief, Schneider, Reckless Ben, and the Schneider Group acquired a direct or indirect financial interest in Brian, Crystal, Benjamin, and or Salem LLC's unsupported claims against plaintiffs, whereby co-defendants with Brian, Crystal, Benjamin, and or Salem's LLC's assistance and support organized and established the enterprise that would launch a campaign of deception, disinformation, and destruction intended to cause plaintiffs injury and damage, to extort a demand of over $200,000. Aha, there comes that value of the Star Wars Lego set that they say on the other side. To deceive and manipulate plaintiffs, to interfere with plaintiffs' economic and family relations, to harass plaintiffs, to cause private and public nuisances, to trespass and to otherwise engage in a pattern of unlawful activities as described herein. So I think that the direct or indirect financial interest they're alleging from Reckless Ben has probably to do with his podcast on the subject. Upon information and belief through the foregoing enterprise, Schneider and the Schneider Group acquired not only a direct interest in the unsupported private claims, but also an indirect interest in compensation, is what I just said, from paid online streaming platforms through which they could publish content they created and disseminated such profit. For example, Schneider earns compensation from online streaming platforms such as YouTube, Patreon, etc., through paid subscriptions and or by other revenue sharing agreements or compensation models.
Yeah, can I make one comment? And this came out obviously since we covered it on the newscast where we tried to be very general, but Patreon, of course, hosts all of his videos and things like that, and they were, of course, asked to take everything down. And very interestingly, they said no. So I think there might be a suit there. BAM against Patreon.
I'm sorry, who was asked to take everything
Patreon.
down?
Who hosts the videos, you pay extra to see certain things. And when, they were requested that all of Ben's videos be taken down, Patreon is a place where they should have been taken down. They were told to take them down. And it's a really funny video if you guys want to look it up, because the owner of Patreon, he's like, yeah, so unfortunately, he's like, we're not going to do it. It was very dramatic. So that's an interesting twist too, that now other entities are kind of involved in this whole podcasting world, right? And what you can show, what you can't show, where's that line? Yeah, I mean, there's so many different facets to this discussion. And I even think you can compare this to John DeLynne's lawsuit, where you're trying to silence somebody who's perhaps a truth teller, and what avenues will you take? There's just a lot. Podcasters should all be aware of all of this because it impacts them.
Thank you for that. Okay, so I'd gotten done with paragraph 62. 63. Upon information and belief, Schneider and the Schneider Group, once again, it's Reckless Ben, have to date received substantial compensation as a result of the unlawful operations of the foregoing enterprise. They wanted to write conspiracy, but they settled for enterprise. Co-defendants engage in multiple episodes of unlawful activities per the enterprise. All right. Now we're getting into the Reckless Ben stuff.
Yes.
Commencing after Baker Salem began operations, that's the news store, as a new franchisee and continuing to date, Schneider and the Schneider Group, with the support of Brian and Crystal, waged a malicious and intentional campaign of extortion and destruction through independent episodes of unlawful activities against plaintiffs. Such included periodic harassment through phone calls, numerous disruptive store or office visits, repeated instances of trespass, deceptively staged events, i.e., disingenuous coronation, rally, raffle, storefront table promotion, a fictitious Lego Club rally, manufactured and frivolous complaints to police, private and public nuisances, threatening phone calls, numerous deceptive live and telephonic impersonations, in person and remote threats, and via proxies, frivolous sham lawsuits, splitting claims in multiple ineffective small claims actions, etc. They might want to use a bracket there at the end, but still, these are all the things that they're talking about. Issuing the publications of let me go back before that so I can pick up the thread. So they're saying that they engaged in deceptively staged events, issuing the publications of defamatory and disparaging images and content, all in furtherance of, say it with me now,
Yes,
the enterprise.
enterprise.
Are you able to read this, Rebecca?
Let me see. Number 65, is that what you're talking about?
Yes.
Yeah. So it says in a YouTube video with the false and defamatory byline, I tracked down the thief who stole $200,000 worth of Legos, posted on 5/21/26 with way over a million views to date. The following representative images and content evidence aspects of the co-defendants' foregoing conspiracy and intention, with Brian with the glasses and Schneider the black t-shirt, admitting we have to do something illegal. Okay. So sounds like BAM is putting forth their own video and photographic evidence of what they're trying to say.
So this is what they're saying. So this 5/21/26 YouTube video, they say minute mark 3, the 3-minute mark. What they're claiming is that they're saying we have to do something illegal. Right. So here's Brian. Like
conspiring.
Is that the picture you had of him on the newscast last Monday?
Yeah.
So there's Brian. He's the owner. He's the son of the older man, but he's the one who's involved here, obviously.
Yeah, he's the owner of the Legos, the son
of the Star Wars Lego. And over here on the right, that's Schneider, right?
Reckless Ben. There he is, right.
Okay. Thank you. And then they have a YouTube video. Looks like it's the same day, 5/21/26. It may be the same one. Yeah. I tracked down the thief who stole $200,000 of Lego.
Yeah.
There's another picture of looks like Brian.
So would this be a scenario where they're trying to prove with these different timestamps, look, they're premeditating what they're going to do. They say they're going to go out and do something that they know is against the law, but they're going to do it.
But and they're saying that they're defaming them.
Right.
I tracked down the thief.
You're right. The title. But when they say I have to do something illegal, does that kind of speak to they recognize that they're going to go out and allegedly do some stuff that isn't cool?
I don't know that that's really that persuasive one way or another.
Yeah.
Whether you say it is kind of not as important as if you do it.
Yeah.
I think it would take away, perhaps, if it says this, we may have to do something illegal, and then later on they do something that may be illegal or maybe not, or maybe pushing the line, and then they say, oh, we didn't know it was illegal. Then it might come up in that kind of circumstance to combat that kind of a statement. Does that make sense?
Yeah.
Okay.
As much as it can. Oh my gosh. Everybody's brain is exploding.
Minute 26:08, same video, I think. We have to do something illegal.
Yeah.
Okay. Upon information and belief, and despite no legal right to do so, co-defendants, led by Schneider and Brian, conspired to engage in a pattern of staged and independent action. So you got Brian now who's hooked up with Schneider, they're saying, and they are engaged in actions, I'm sure as far as Brian's concerned, to try and get the Lego back, in a pattern of staged and independent actions or events, inter alia, among others, to harass, intimidate, interfere with, disparage, defame, extort, misrepresent, falsely portray, and damage Josh and Brandon, as well as their business, Baker Salem, back in Oregon, BAM. In other words, they're also trying to damage and do all these things to BAM and other franchisees of BAM in a variety of ways. Evidence of co-defendants' ongoing conspiracy and illegal actions and or misconduct are depicted in the following video. It's called video publications, excuse me. The video is published. For example, 5/21/26 YouTube video titled, I Tracked Down the Thief Who Stole $200,000 of Lego, found at the following link. That's when they were referencing above. A downloaded and viewable copy of the video is provided to court along with an informal transcript of the statements contained therein as Exhibit C.
Yeah, that's what I meant when I said the judge is going to have to watch an awful lot of video, because I think their evidence on both sides is video, and it'll be interesting.
I would just watch the timestamps.
Yeah. I know, but even though they're out of context, you know?
It is the plaintiff's job to tell you what's important for their case.
Right.
Okay. And if they provide a big video and give you timestamps and you're the judge, I watch the timestamps. I don't watch the whole video. Does that make sense?
It does, except for context, you know? Sometimes
it's up to them to give the context. And if the other side, the defendants, when they file and they think context is important, then they'll do the same thing.
So they say, Your Honor, if you run it back 2 minutes, you'll see that what I was really saying was,
these lying scallywags didn't even include the timestamp that gives the answer to everything and shows that their allegations are full of hooey, that kind of thing.
Wow. I don't know how the world is going to survive this court case. It is already...
The way the world is going, I consider this court case to be a pleasant distraction.
You know, it is. It's a summer thing, isn't it? It seems like in summer, sometimes these things pop up and everybody just kind of gravitates and it catches their interest and catches fire. I think this is one of those examples.
So another example they give is a 5/21/26, same date, Patreon video, same one, titled, no, maybe it's not, titled Lego Video Part 2, found at the following link. And there they give that link, accessible exclusively through Reckless Ben's subscription-only Patreon channel.
Yeah, not all of his videos are on Patreon. Just some of the videos are on Patreon. So,
a downloaded and viewable copy of the video was obtained and attached to the court's record and convenience, along with an informal transcript of the statements contained therein as Exhibit D. Another example, same date, 5/21/26 YouTube podcast video titled, I Got Arrested Investigating a Lego Store, found at the following link. A downloaded and reviewable copy of the video is provided to court along with an informal transcript of the statements contained therein as Exhibit E. Yeah, this is not going to go over well. Now you're getting into the place where they're not giving timestamps.
Yeah.
And they're basically telling the judge, look, you got to look at the whole thing, and here's a transcript to help you.
Yeah, look what
I don't know how long this is,
Yeah.
but this is the kind of thing that judges are not fans of.
They hate this, right? They want to understand what they're supposed to see, right? And they don't want to go
If you're going to give this as an example, okay, of what it is you're talking about, that you're claiming there's been this defamation and damage, it's up to you to prove it.
Right.
And nothing in here does that. Nothing in C does that. See what I mean?
Mm-hmm.
You can look at the other ones like, caught a thief. Okay, just the title tells us something. And they had some timestamps before, which could direct you to the places that the plaintiff thought was important. But here in C, all I'm seeing is the link to an entire podcast and nothing else. Let's see if D does the same thing. It does.
Wow.
This is 2 days later on May 23rd, 26, a YouTube response video titled Bricks Minifigs responded to my video. And they're saying, okay, you can find that at Exhibit F. Thanks a lot, the judge says.
So is we're like, what, 20% done with the claim? Is the majority of it just, hey, look at this and look what else they did. And here's a picture of this and look at this video and check that. I mean, that's really what the next 60 pages are, isn't it?
Well, we are past where I have gotten to in my brief review after I got a hold of this.
Yeah.
This morning.
No, I mean, as I scroll through it, a bulk of it is just these kinds of things. Here's a picture where he did this. Here he is doing that, and a little bit of their version of what they see happening there. So I guess that's standard if you're trying to prove all those claims.
Well, they're putting it all out there. They don't have to put it all out there. They have to put out enough to support a claim. In other words, if the other side comes and says, hey, you don't have enough evidence against me, and therefore I want this lawsuit tossed, in a summary judgment motion, you should have enough to support your case, right? But this isn't supporting anything. All this is saying is it's looking at these videos and saying
Right.
there's evidence in there. But evidence of what? We know what you're saying it is, but where is it in that video is the question I would
Right.
have if I were the judge. And it gets worse in E. Any and all other videos, post, podcasts, social media content, or other publications by Brian Schneider, the Schneider Group, or any of their agents, whether already posted as of the date hereof or posted in the future, that relate to, reference, or concern McNeff's, Josh, Brandon, Baker, Salem, BAM, or any BAM franchisees, the plaintiffs, whether or not specifically identified herein. Okay? I'm just not sure how that advances the case anything at all.
Right.
I mean, look, I don't do a lot of civil law. I did some, but I don't think there's anything in civil law that says you have to put all of your evidence or references to all evidence in the case in your complaint.
Yeah, I think that's why this complaint is so long. And I'm kind of scrolling through, and it really is just a series of pictures and pictures. And look, here's this, and look, he did that, and here's a picture of him doing this. And it seems like that is why it is 95 pages long.
The last 20 pages or so, by the way, are just the different causes of action. So thankfully, we'll
Right.
be spared that. That's not.
Yeah.
And when you get to the causes of action, complaints are like 4 parts. The first part is the heading. Second
Right.
part is going to be about the parties. Maybe it'll be 5 parts. The next part's going to be about jurisdiction and why it
Right.
is the court has jurisdiction. We saw that. That's very important. It's just not usually very interesting. And then you get to the facts of the case, and that's what we're in. That's the most important part, at least the most interesting for me, because that's where you find out what the case is about, or you're supposed to. And then at the end, you get to the causes of action, which is saying that on the basis of all of these facts that we've adduced in our complaint and set forth in our complaint, that we are bringing the following causes of action. In other words, we're saying these are the legal things that we're bringing against them,
Right. That makes
whether
sense.
it's going to be harassment or trespass or whatever.
Right.
But it's going to say incorporating all of the facts that we just listed. They're not going to repeat them again for each complaint. We're going to make these allegations, these causes of action that we feel we have against the defendants. Okay. So 67 says, as evidenced in the 5/21/26 YouTube video and publications, beginning in early 2025 and continuing to the date hereof, i.e., over a substantial period of time, and with the direct and indirect support and encouragement of Brian, Crystal, and Benjamin, Schneider and the Schneider Group began targeting the Baker Salem store and BAM to unlawfully shake them down and extort monies demanded. These targeted activities were directed at plaintiffs and included inter alia. What does that mean, Rebecca?
Inter alia? How are they using it?
Among other things. It's a third time we've
Yes.
used it.
Oh, that's right.
It was a pop
Okay.
quiz.
Okay. A pop quiz. How can I take a pop quiz? My brain is exploding from all of this. So,
Latin
yes.
is the language of
And
the
else. Yes, exactly.
Yes. Greek is the language of science. French is the language of the dance.
Of the law.
These targeted activities were directed at plaintiffs and included inter alia, the following reported distinct actions as evidenced in the publications. So publications are basically, I think, the videos. Appearing in person and confronting and harassing staff, encouraging third parties to harass employees, facilitating threats towards staff, obtaining signatures under false pretenses, deceptively distributing counterfeit raffle gift certificates, and attempting to collect, repeatedly trespassing, staging protests, defacing property, defaming and disparaging plaintiffs, threatening destruction, injury, and damage to plaintiffs, and issuing and circulating dozens to hundreds of fraudulent certificates, placing plaintiffs in a false light, publishing defamatory statements, among other episodes of unlawful activity, as detailed in part below. I hope they're a little more specific than you said scrolling through, Rebecca.
Yeah.
Following this 5/21/26 initial video, which is why we've heard this date so much before, in the publications and on 5/21, same date, BAM responded by posting a note to our community about the Bricks and Minifigs Salem, Oregon store. Attached is Exhibit G, clarifying that the underlying dispute related to a private consignment arrangement allegedly made at the former Salem LLC store, debunking the entire premise of the unlawful and extortionistic enterprise. 2 days later, May 23rd, 26, Schneider, Reckless Ben, released a YouTube response in which he recklessly, well, that's why they call him Reckless Ben, I guess, in which he recklessly dismissed BAM's clarification regarding the private consignment arrangement and doubled down on his false narrative, stating there's no reason for these Legos to be in their store. They didn't pay for them. I'm guessing that's because this is in association with his finding them in the store. Is that right? Or his
I'm
claiming he found them in the store?
I'm guessing, yeah.
Okay. There's no reason for these Legos to be in their store. They didn't pay for them, which makes
Right.
sense if
Right.
it makes more sense if he's saying he saw them there.
Right. Yeah, they're purposely not saying that. I wonder. It's interesting.
So they give the timestamp there. This statement demonstrates Schneider's willful disregard for the legal realities explained in BAM's response. Well, it's just your defense. I mean, legal reality. Your defense is true. Yeah, there's certain legal realities, but I don't think that's what he's contesting.
Right.
He's contesting whether what you said is even true in the first place. Legal realities explained in BAM's response, namely that BAM acquired the store's assets as a bona fide purchaser without notice of the unauthorized private arrangement, and his intent to further mislead his audience and to incite continued harassment against plaintiffs in furtherance of the enterprise. Extortion, harassment, and threats of violence, Part 1.
Part 1. Oh my goodness.
Hang on a second here. It's getting hot in here.
I know. Good.
Oh my God.
We're like
Representative
on page 20.
Yeah. Representative images and content evidencing Schneider and Schneider Group confronting and harassing Baker's staff and employees are set forth below. So when it says Baker, it's talking about that store in Oregon under the new management, right?
Oh, yeah. They haven't even come to Utah yet. I mean,
Yeah.
that'll probably be page 75.
That 521:26 YouTube video, and it gives the timestamp of minute 1246 through 1446, 1246 through 1446. Schneider attempted extortion and directly threatened Ammon by stating that if you just want to give it back now, it's going to be a lot easier for you guys. You know, I think you guys would prefer the easy way or the hard way. I don't think you guys are really going to like it. Not
So
sure how
that's
that's either extortion or a
Yeah,
direct threat.
That's what BAM is saying that Reckless
Okay.
Ben said to them, and they're
That's how they
taking it
characterize it.
to mean yes. Yes.
An implied depiction of the threat and violence associated with the hard way is an explosion at BAM's corporate headquarters. Implied depiction.
Oh,
Oh, okay.
Okay,
This is the
yeah.
threat that they're saying.
there it is. Yeah. And this
That is-
is in Oregon still. Am I right on that, RFM?
Yes, I believe so.
Yes, because we were kind of
Or
asking. in
but
the
they're
chat.
saying that the threat and violence that they're saying is associated with
Would
the
be
hard way is an
corporate.
explosion at BAM's corporate headquarters in Utah.
Right.
Is that an explosion or is that like different, like some different colored sponges put together?
Do you know when the reason I'm looking down at my phone is I am scrolling through the lawsuit there kind of to keep tabs. And for a minute, I thought it was like a Rice Krispie treat. I couldn't really see.
Rice Krispie treats.
I
I saw the biggest
know.
Rice Krispie treats at a farmer's market the
Yeah.
other day. I didn't get
Oh
one.
my gosh, they're so good with chocolate.
Okay, same video, right? 521:26 YouTube video, minute 18:22. Victor and a member of Schneider Group, each acting individually and as agents of Schneider, pretending to be a celebrity and a member of a fake Lego club in order to trick an employee into unlawfully disclosing Josh's contact. They're trying to get a hold of Josh, right?
Okay.
Who is now one of the operators of the franchise. His contact and other information to further harass and interfere with Baker, Salem, Brandon, and Josh's business. So they're saying they went in there and pretended to be a member of a Lego club so they could get Josh's contact information and call him and tell him all the great stuff about their Lego club. Okay. Do you know who this is? Let's see if it says below.
I'm guessing this is the impersonators.
Along with Victor. Maybe they did a selfie. Okay.
Yep, there it is. Impersonating Guinness World Record. Scroll back up. Personnel and delivering a disparaging, misleading, and fake award for most Legos stolen.
I would have thought that would have been below. Yeah, see, that's below. They just,
Oh, that's the award. Okay.
yeah. And that's the 52126 YouTube video, minute
Right.
1 hour 17:52. Impersonating Guinness World Records personnel
Right.
and delivering a
Right.
disparaging, misleading, and fake award for
Yep.
most Legos stolen.
Yeah.
Okay, so there's a framed award. It says Guinness. The most Legos stolen by a, I won't even ask if you can read it, something franchise, single franchise
Yeah. Yeah. They're just
for
making a point.
$200,000. Yeah. I can't read the rest of it, but so
Yeah.
that is a prank award. Now they say fraud, deceit, impersonation, and forgery through false document scheme. Upon information and belief, Schneider admitted disguising a document as a delivery signature, then claiming it is a get out of jail free card, and that an employee owes $5,000 each time she calls police. Upon information and belief, the document was obtained by deception and was not knowingly signed as a contract and is unenforceable. Do you know anything about this, Rebecca?
Well, no, I mean, it was just, I don't know. It seems to me, and somebody mentioned this in the chat, parody. Some things are certainly covered, I
Mhm.
would think, legally under some protections. So,
Like the First Amendment.
yes, some protections. That's right. So, trying to make a point through parody, is that harassing? I mean, again, the judge is going to have to wade through all of this and decide, but they were going to the Oregon store. They were doing these things to point out, look, this guy's Legos were here and they're not. You know, what do y'all think about that? Right.
Upon information and belief, the document was obtained by deception and was not knowingly signed as a contract and is unenforceable. The signature requests made under false pretense echo the fraudulently obtained signatures on fictitious contract documents previously used in Salem, suggesting an intent to fabricate legal claims or evidence for extortion and harassment purposes. Representative images and contents evidencing the foregoing are set forth below. Okay, good. So we got the 52126 YouTube video. Once again, the one that talks about I caught a thief. Schneider and a DOE member of the Schneider group, Joe Doe, excuse me. In other words, they got pictures of people who are on these videos. And here's one of them. We don't know who he is, but that's going to be a John Doe when we do figure it out. I think that's what they're saying. Schneider and a John Doe member of the Schneider Group drafted a licensed merchandise and promotion agreement with an absolute non-trespass covenant, Clause 6, then fraudulently obtained a Baker Salem store manager's signature by posing as federal government employees like a USPS or UPS delivery personnel. Schneider later unlawfully threatened and demanded payment of $40,000 for alleged violations of the forged agreement accompanied by threats. So it sounds like they're saying they sort of did a Radar O'Reilly thing
Yeah.
by going in there and pretend, worse than what he did. But going in there pretending that they are a UPS delivery driver,
Yeah.
get a
Yeah.
signature,
Yeah.
and then transferring that signature over to some kind
Yeah.
of other document is what they're saying. And then they're saying that Reckless Band later threatened and demanded payment of $40,000 for alleged violations of the forged agreement, accompanied by threats. I'm guessing that this part was also there. $5,000 each time she calls the police. 5 times 8 is 40,000. Chance, this card may be kept until needed or sold. Get out of jail free card. Yeah, we've seen that before. That's from Monopoly. And here's a picture of the licensed merchandise and promotion agreement that they're saying has a forged signature on it. Do they really sell thief? IEF? They have to remember that rule, I before E except after H.
Yeah.
And here they have that one provision under subsection 6 of that agreement. Absolute non-trespass covenant, I'm guessing is what it says. The first part of covenant is smudged out. Okay. And dispute resolution. Okay. So here they have a picture that they're alleging is somebody. By the way, is that Reckless Ben there? Can you recognize him?
Yeah, I think you can tell from his hair.
Well, okay. I know this thing is in front of his face, partially
Yeah.
obscuring it, but it's upside down, and it looks like USPS first class package is what's on the front of it. Okay. It looks like it's at a garage. It's at a garage. It's at a gas station, and it looks like is it going up to somebody in a car?
Yeah, no, I think they're showing what they're going to do. I did not watch a lot of the videos from Oregon, so I am a little light on my knowledge there. So if anybody else knows, I think they were showing how they were going to do that or how they did do that.
Okay.
Yeah, they had the fake, they had somebody posing as a UPS. They had a little thing on the hat and all of that. So
Very good. Off to the good old days when gas was only $4 a gallon
that's, yeah.
back in May.
When was that?
And here's some more pictures with a package, and it does look like Reckless Ben with
Yeah.
someone else
Yep.
who may
They're
be
putting the label
Victor.
on. See, they're going to go do it, I think.
And it is at a gas station. Yeah.
Yeah.
Okay. And here's the guy who's not Reckless Ben
Right.
with the package.
Yep.
And here we are going into the store in Salem, Oregon. I got a delivery. I have to note that at the bottom left, it says November 2nd, 2019. Do you see that? The timestamp on the video?
Yeah, I do see the timestamp there.
That would seem to be an error. Don't you agree?
Yeah, I'm not sure why it says that. Yeah,
Because it's supposed to be May. I think it's supposed to be last month.
exactly. I know. Oops, my screen. Like I said, I did not watch everything from Oregon. I've watched everything else, so it is. Yeah, but I think
Okay.
that's what that is. I've seen the screenshots.
So
So
it's as if this is a body cam coming into the
yeah,
store.
yeah.
And the guy with the beard
There's
saying, "I got it."
so much content. It's absolutely overwhelming, isn't it? I had to take a day off work just to watch everything that I could.
Okay, so here is the signature going on, I believe, signing for the package.
Yep.
Once again, it says 2019. That's just got to be in error, I think.
This is an error.
Not the first time I've seen it.
It's just wrong. That's all.
It's also why
wrong.
I'm always very, suspicious, leery of timestamps on videos
Well,
or
I know. Yeah. You never
cameras
know.
because, unless you have made it, set it to the correct time and it's going, it may show 2019 when it's actually 2026.
Yep.
The problem is when the errors are not so obvious in the timestamps, where it could say a day off or
Yeah.
the time is off.
Yep.
And that can really lead to problems. This is pretty obviously not correct. Okay. In witness whereof the parties have executed this agreement, blah, blah, blah. Oh, in other words, they got this lady at the store whose name I think is
Yeah.
Amanda
Yes.
to sign off on this dumb thing
Yeah.
where they're having her agree and think that she's legally bound or the store is
Yeah.
legally bound to
Exactly.
this.
Yeah. Yeah.
Shall be liable to licensee for $5,000 per police officer called.
Yeah.
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 Okay, so that's a prank. And there's the same thing. Or by calling the police on Ben Schneider, $5,000. Okay. So anytime that you call the police on me again, I'm assuming it's again, it's going to cost you $5,000. And we got one of your employees to sign off on this through this
Yeah.
route. Okay. Here is $500,000. Oh, plus 5,000 equals 10,000. So in other words, the cops being called. And here's another 5,000. Now it's up to 20,000. Guys, they keep calling the cops on. Reckless bin. Now it's up to 40,000. Yep. See, that's where the 40,000 came from that he's claiming. Or at least that they say he's claiming. Whose signature is this then?
Yeah. Look at that
No,
picture.
it's not. So she's probably now saying it's not her signature because she has no recollection of signing any document like this because she didn't. And yet it would look like your signature. But then again, I don't know. On those little pads, it looked like she was
Yeah.
signing on.
Oh, yeah. No, mine is a straight line. So yeah, you could never.
Yeah.
That's
So,
funny.
I mean, if I sign my full name, I would be able to tell if it's my signature. But
Yeah.
maybe, you can't when you're just signing on one of those.
No.
Fake unauthorized raffle. Good. We get to find out about this. They mentioned it before and I was interested. In or about April 2025, members of Schneider's team set up a fictitious giveaway from the Salem store and falsely impersonated and claimed to be Baker Salem store staff members or affiliates to the public. Is this going to be like when you got a neighbor that you don't like, and so you call up the pizza parlor and you order 10 pizzas to be delivered
Delivered
at
to your
his
house.
address? Okay, this
Yep.
was not that I've ever done that, by the way. No, I've never done that. I might. This was reported, and the Kaiser Police Department investigated. So there's the investigation number. A detailed incident log documenting the continuous disparagement and harassment campaign, including corresponding law enforcement case numbers from April through May, and that's April 2025 through May 2026, is attached as Exhibit 1. So you got the law enforcement reports there. That's another prank. Fictitious giveaway from the Salem store. And I'm sure that's where the raffle comes in. Representative image and content evidencing Schneider and Schneider Group distributing an unauthorized raffle tickets. Unauthorized raffle tickets and associated a fake gift certificate is set forth below. 5/21/26, that same YouTube video, right? Schneider, Victor, and Schneider Group conducting an unauthorized raffle of purported Baker Salem merchandise. So if they have a raffle of merchandise, then people take the tickets and go to the store and say, I want
Yeah.
my
Hey, I
Lego.
won this. Yep. Where is it? I won it. Exactly.
And this is why they're having to say the Schneider Group and the Does 1 through 15, I think, is because in these videos, there are obviously people who are involved.
Right. He has a team. Absolutely.
And they don't know their names yet.
Right.
Because why would they?
Yeah.
So now, this is part 1, defamation, vandalism, and trespass. There's so many aspects to this. Separate actions by Schneider and the Schneider Group directly targeting the Baker Salem store and indirectly BAM included trespassing to deface and post defamatory signage stating BAM stole a family's life savings, was sued, lost, and closed to avoid paying when it was closed, that store. Affixing materials to windows, acts of vandalism, and continued trespass, which Schneider allegedly later admitted, and distributing shirts, flyers, and banners with false and misleading statements and disparaging BAM's brand. Representative images and content separately evidencing Schneider and Schneider Group's furtherance of acts of defamation by allegedly creating an Oregon entity with a name we steal from old people, a website, and an illegal logo for the admitted purpose of disparaging BAM are set forth below. I want to see these. So 5/21/26, that YouTube video, minute 27:16, Schneider and Schneider Group created a logo for their alleged new entity with their slogan being Bricks and Minifigs. We steal from old people. And there's a burglar under a streetlight with some Lego and an elderly gentleman with only one tooth crying his heart out in the circle at the bottom. And they merged it. They put it on a t-shirt, they did. Kind of clever. Schneider also set up a booth outside a BAM franchisee store location in Salem, Oregon. And by his own admission, impeded, stopped, and redirected customers from entering the store directly interfering with plaintiffs' business operations and intimidating and scaring customers and compromising customer relationships. They say that as if it's a second store that's not associated with the other store. Because it says a BAM franchisee store. If it were the
Yeah.
same one, I would think they would say that, but it's in the same town, Salem, Oregon. So maybe they
Drawing
have more than one.
attention at different locations. Yeah.
Representative images and content separately evidencing Schneider and Schneider's group's acts of vandalism to creation of a website entitled we steal from oldpeople.com, selling disparaging merchandise, including the t-shirt, I'm sure, trespass upon and defacing of Baker Salem's property, using false, disparaging, and defamatory statements are set forth below. Once again, to that 521 YouTube video, it's doing a lot of work in this complaint. Member of Schneider Group trespassing and climbing ladder to the top of Baker store, wearing a Lego yellow head covering to illegally deface and hang a defamatory banner sign stating we steal from old people. Separately, Schneider is trespassing and tabling outside the Baker store to stop customers from entering the store by sharing false and misleading statements depicting theft. See, here they say the Baker store. I don't know if they meant to before and made it sound like it's a different store, or if it is a different store.
Right. And again, I think it's time for a disclaimer because I have seen some things in the chat saying, why is this channel supporting BAM? Would you like to address that, RFM? For the fifth time, we're making the disclaimer.
I'm not supporting anybody. I'm reading a complaint that was recently filed by BAM. And we're going through the facts so we can understand what their allegations are. We're not saying that we believe them or that they're true. We're just going over a complaint. And then once we understand the allegations they're making, I will be better positioned to understand the response, which will be given by the defendants, which will be filed in due course, and which we will cover at that time.
Yep. Very
Does
good
that make
point.
sense?
It does make sense. Yeah.
Okay, good. Yeah. It is possible to look at this objectively, and that's what I'm trying to do. Okay, so here's a picture of somebody with that yellow Lego covering. It's either that or a paper bag, I don't know. Climbing up, they're saying to put, or saying it's on the video, to put up that sign on the outside of the store. Oh, it is a, I'm sorry. It is a Lego head. Okay. And there's the sign, I think. Okay, so Bricks and Minifigs, they've duplicated their name and the way it's shown. And instead of rebuild, reuse, reimagine, they have we steal from old people on it.
Yeah.
Got it. Okay, and there is Reckless Bin next to that sign that was just put up there. And here's some of the merch. Here it is. We've got the t-shirts. We've got the wristbands. Do you recognize any other merchandise out there?
No, I've never seen any merchandise in the wild. I've never seen anybody wearing a t-shirt or anything, but I'm guessing that the merch will only increase at this point.
And I'm guessing that this is the table they were talking about, or at least alleging was set up outside their store in Salem, Oregon. Looks like it. Could be. So there he is outside the store. Reckless Ben in the video. And there's the table. Bricks and Minifigs, we steal from old people. What's going on inside is so disgusting, it's going to make you want to throw up. So it's a vomit bag. And a coffee cup. Okay. Yes, we did see that the first time.
Is it usual, though, RFM, to have all of this in your complaint? I mean, I guess maybe you're building.
This I would.
It is. Okay.
This I would put in there because these are specific things that are demonstrating, at least you're alleging they demonstrate, the kind of harassment that you're undergoing and the defamation that's being brought about.
Exactly. And again, these are not our slides or anything we've created. This is a legal document, including pictures. We have not gathered these together to support BAM or show anything like that. We are reading through a legal document that BAM has presented against Reckless Ben. It's important to know what they're saying he did, right?
Yes, if you want to understand what's going on, it's best to hear both sides of the story. I have
It
always found.
is. It is.
And this
And
is
we
their
all
side of the
know
story. We're not vouching
exactly.
for it.
Yeah, and we all very much know as we read through this, we can be our own lawyers here and say, you know what, I would counter this with this, right? We
Right.
can all come up with those things in our heads. But for anyone that's confused that these are some kind of slides we put together to defend BAM, we are reading through a legal document.
Mhm.
I do
This
feel
is
like
what
I'm on
BAM
talk
and
show.
the plaintiffs are gonna be held to account for because now they
Exactly.
have
Yep.
formalized their complaint and put it in
Yep.
a
And what
document
was
to
the
be
date
filed
of
with the court.
this, RFM? What was the date of this?
May 27th.
May 27th is when this was
I
signed.
signed. I'm not sure when it
Yeah,
was
and
filed.
I'm not sure when this really became I only started hearing a couple days ago, "Look, the complaint is out, they're suing Ben." So, we were lucky to get our hands on it. I don't know that a lot of people have. So this is the actual document that you guys are
Yes,
seeing. Yeah, it's not
yes.
something we put together. This
There's
is
only
the
one thing.
actual legal document.
Here's the only thing I'm vouching for. I'm vouching for that this is the complaint that BAM has filed.
Yep, that's the
That's
only
it.
thing we can say. Yep.
I can't make it much plainer than that.
I think you have to make it that
521:36.
plain about every 10 minutes, though. I think we have to. So
Okay. I'm sorry, I was looking at this next part. It says Snyder and Snyder Group defacing Baker Salem store, further interfering with its customers after redesigning signs affixed to the store to make them way better, i.e., change buy to steal. Okay. Here's some more signs. It says turn and go home. Oh, buy, sell, and they're going to put steal over trade. That's what they're going to do, right?
that's it.
That's what they're talking about.
Yep.
On or about 3/6/26, Schneider, Bryan, and the Schneider Group trespassed again and placed a defacing and fake sign on the Baker Salem store which read, permanently closed. We stole a family's life savings. They sued. We lost. That's the sign you showed last Monday, wasn't it?
Yeah, that's the
So that's on
sign.
the Baker Salem store, not on anybody's residence.
Mhm.
Permanently closed. We stole a family's life savings. They sued. We lost. This vandalism was documented in a Facebook post on the Salem Kaiser community page, which includes photos of the sign and people, including Schneider, trespassing outside the store. Can you trespass outside a store?
I'm sure there must be some kind of easement around the store. Isn't that
No, I don't
no?
know. I suppose it depends. I mean, if you've got a house and it's on
Yeah,
property, right?
yeah,
But if you got a store that's like in a, I don't know, a strip mall,
yeah.
it's hard to trespass outside a store in a strip mall, but that's what they're saying. Maybe it is not in a strip mall. Maybe they actually own the outside part that they're saying they were trespassing on. Kaiser Police Department investigated this incident. Representative images and content evidence of Schneider and a John Doe. It could be a Jane Doe, by the way. They just put Doe up there. And a Doe co-defendants vandalism and trespass are set forth below. Okay. Oh, so they're saying on the inside of this fence
Yeah.
here, right here.
Yep.
I think they're saying they must own that if they're going to allege trespass, at least to make it stick or make it meaningful. Um, that's very close to the property line.
Yeah, that really is. I only reckless Ben could fit back there, I think.
I couldn't. I'm betting that was
I couldn't
grandfathered
either.
in. Okay. So, let's see here.
See? There you go.
That wait a second. That fence at the bottom left it looks a lot wider in this picture.
Hmm.
Looks like there's a lot more room there.
Yeah, I don't know.
Wait a second. I wonder if this is a composite picture. Because there's no frontward facing part of the fence. You know what I'm saying?
Yeah, no, I
When
don't
it comes
know.
around the
It's a
corner,
weird
look
angle.
down here.
Anyway, BAM feels that's
Down there.
relevant and important to put in the complaint. So there it is.
Okay. Yeah. All right. So permanently closed. Here's a sign that they were alleging. We stole a family's life savings. They sued. We lost. By closing the store, we get out of having to pay the family what we owe them. So those are the allegations coming the other way, that they closed the store intentionally, or at least knowingly, that by closing the store, then they didn't have to pay the family what they owe them. Okay. Obstruction of justice is the next category. While engaging in their ongoing trespass, multiple incidents recorded. Schneider and Schneider Group employed deceptive tactics to evade police investigation and to obstruct justice. Representative images and content evidencing Schneider and Schneider Group members' acts of deceptive tactics are set forth below. That same damn video, May 21st, 26. Upon police arrival at the scene, Schneider obstructed the investigation by directing a colleague, also named Ben, to wear identical clothing to take Schneider's place, thereby evading identification by law enforcement and avoiding being arrested for trespass. Okay. Does that make sense to you? Do you understand that, Rebecca? So they're saying he trespassed on the property, police are on their way, and so now he's having another guy impersonate him so that he won't get arrested. That's their allegation, and they're saying it's on the video. There's a screen grab from the video. Profiting off counterfeit merchandise. During this time period, and in an attempt to justify his deception, Schneider promoted his website and merchandise using the phrase, "We steal from old people," thereby facilitating his false branding, interference, harassment, and defamation of BAM and its franchise system and franchisees as elder theft criminals. He promoted this website, westealfromoldpeople.com, and merchandise to the Schneider Group and his YouTube followers, urging and inciting them to join and support a campaign of harassment and disparagement against BAM and its franchisees. There have been a number of corrections that could be made to this to make it correct. There's a lot of small grammatical errors. I'm not sure about the big errors, but there's a lot of these small errors in here, which indicates it was done somewhat hurriedly. And also the fact that they didn't do timestamps for some of those videos is another indicator that it may have been done in a rush. This conduct diluted plaintiff's brand and commercially disparaged it and its franchisees. Representative screenshots and evidence of this campaign are attached as Exhibit H. So I think that what we can say is that if BAM or, well, let's just say BAM right now. If BAM was involved, were involved in the illicit taking of this property, and that's true, which Ben's basically going to have the burden of proving, that should pretty much be a complete defense. Maybe not to the trespassing, possibly, if that sticks, right? But all this harassment stuff and defamation stuff, if it's true that BAM did this, then it's not defamation. It's just telling the truth. And telling the truth is a defense. So that's going to be front and center in this case, which should be interesting to see that evidence when it's brought forth. Rejected settlement proposal. In late 2025, and based on co-defendants' ongoing harassment, Brandon and Josh further investigated the Baker-Salem store inventory. And though they still could not reliably identify any product that appeared to belong to Brian, they located a few, approximately 20 Star Wars Lego sets in a back office. Wait a second. Okay. This is the magically appearing Star Wars Lego sets. Remember earlier in this complaint when it said that Josh, I think it was Josh, did an informal and brief.
Or Brandon, I think, did an informal and brief.
Was it Brandon? It was Brandon. Okay, Brandon and or Josh did that informal. And I was wondering, why did they say it was brief? Well, the reason they said it was brief and informal and basically cursory when they said he did an investigation of the inventory and didn't find anything is because they know he's going to find stuff later. That's why. Any thoughts from you on that?
Really? You think so? So they're going to say, yeah, we tried to look, but it's perfectly acceptable that we didn't see anything. And oh gosh, don't scroll back. Oh,
that's why I said it was 44.
It's making me seasick. No, that makes sense. They had to say that because because then you could say, well, later we did a more comprehensive, and that's why we located it.
Yes.
That makes sense. But there's some photographic interesting evidence there. So we'll see.
I'm going to trust people to remember that, where
Yeah.
that happened, and to look it back up or replay it if you want to find that. But yeah,
Yeah.
that's stuck in my memory because
Yeah.
I wonder why they say it was a brief search that they did of the inventory when Brian came to the store, remember? And he was very upset, allegedly, and understandably if he was.
Understandably,
So
yeah.
where's my Legos? Well, let me go look in the back. And they say, he looks in the back. This doesn't seem like a really big store. I don't know. Maybe they got a lot of stuff.
Yeah. But here they are.
He does
They've
a
found
cursory
something.
search.
Yeah.
I don't know if you got a guy
Well,
out there. This seems pretty emergent. In other words, you got a guy saying, hey, prior, I gave 60,000, 80,000, a ton of Lego stuff from Star Wars Lego to the store on consignment. It's not here anymore. Where is it? I would go back and I would probably be doing more than just a cursory brief search.
yeah.
But they say he did a brief search so that they can explain why it is that when he was doing his brief search, then
He missed it.
he didn't locate these 20 boxes.
Right. Well, and the Legos were apparently marked in a certain way to indicate they were part of the set. So that's a question too that I know everybody has strong opinions on, and there is some photographic, alleged evidence on that too. Why there were marked, they were marked and then seemed not to be marked. So all of this will come out in court. Everybody will be able to present what they have.
And this is the part they're admitting to. So this is something that immediately raises a red flag. Now, is it possible that that's all true? Yeah, it's possible. It's just that when you go search for somebody's missing Lego sets, Star Wars Lego sets, and you don't find them in the back room, and then you go back in late 2025,
and there
like
they
almost
are.
a year later, and all of a sudden you find 20 Star Wars Lego sets in the back office, lockable cupboard. It didn't say it was locked, by the way. If you say it's lockable, but you don't say it's locked, it wasn't locked. On which they noticed stickers not previously recognized. Hey, these boxes have stickers on them. These boxes
the
we
stickers.
didn't see before.
Yeah.
We didn't see the stickers and we didn't see the boxes, but now we see the boxes and they got stickers. And there's 20 of them. Yeah. As a precaution only, but still without knowledge that Brian, in fact, had any right there to. But it looks like, wait a second, these might be Brian's Legos. You got to be thinking that. They directed that such not be sold from Baker Salem's inventory. Don't sell them from Baker Salem's inventory and remain locked up pending completion of their ongoing investigation and receipt of reliable evidence of ownership and other conditions. Okay. So it was in a lockable cupboard. That's why they didn't look in the lockable cupboards when they were looking for the Lego sets. I don't know why not. On or about 12/3/25, in a text exchange between Josh and Brian, deceptively orchestrated by Schneider, and after sustaining incredible business disruption and harm, Josh discussed a possible settlement scenario under economic duress. Uh-oh. They want to walk back this settlement scenario, don't they? So, purely as an accommodation and without any legal obligation to do so, Josh discussed a possible settlement scenario to allow Brian to retrieve the few sets that had been provisionally identified as merely Star Wars related product in the back office, i.e., described above, though not necessarily belonging to Brian. We don't know if it's Brian. Just these Star Wars Lego things in the cupboard that have this special label on them, which, as a precautionary matter, I'm not sure why they would be giving them back to a guy unless they figured it was his, which, as a precautionary matter, Josh had set aside pending receipt of ownership documentation from Brian. Yeah. Josh indicated a written apology and other concessions would need to be made, and the harassment must stop. Okay, so Josh Johnson says to Brian, and perhaps to Reckless Ben, they need a written apology from them, and other concessions would need to be made, and the harassment must stop, and they'll give back the boxes. Brian rejected this proposal outright and responded, unless you are going to make us whole on the whole Lego collection, I don't see where we have anything to discuss. Yeah, don't just give us these 20 boxes. This confirmed the enterprise's interest. Referring to the sets he had identified, Josh replied, we can give you what was left when Presumably, Crystal left. We can't and aren't responsible for what she sold the 2 years y'all were working together. It was 1 year. If you want what she left, let me know. Brian refused this offer. This exchange further evidenced Brian's objectives were not about recovering a Lego collection, but rather about extorting payment for the enterprise beyond any legitimate claim. I look at this and I say, no, I don't think that is what it really shows. I don't think it evidences that. It could evidence that. But what is much more likely is that here you got a guy, Brian, who, the whole collection. And now we've been through this for a year and then 2 years. And now they come up with 20 boxes. By the way, one of the conditions, the other concessions, where it says Josh indicated a written apology and other concessions would need to be made. One of the other concessions is signing a document saying, okay, all the parties are released. This ends with the return of the 20 boxes, right? Obviously. I mean, you can't just give them 20 boxes and let them keep. It has to end the dispute. And in order for it to end the dispute, the parties have to sign a document saying this ends the dispute. And I am virtually certain that would be one of the other concessions that they're not naming here. And that's why Brian, of course, rejected it. I'm not going to take the 20 boxes and say, I'm good. No, you got to give them all to me.
Yeah.
I think that's what's going on there. And that's why I think that it's not necessarily, as they allege, evidenced Brian's objectives are not about recovering a Lego collection because he wants it all, but rather about extorting payment for the enterprise beyond any legitimate claim. Extortion, harassment, and threats of violence, part 2. On or about December 11th, 2025, a member of Schneider Group admitted and or revealed conspired unlawful actions to a BAM employee, i.e. Adam Brimhall, that they had already taken actions and regarding planned future harassment, extortion, interference, and vandalization of BAM. This conversation was reported to the Provo Police Department by BAM. See Exhibit I. In December 2025, Schneider and an associate entered and unlawfully remained at BAM's corporate offices in Utah. Now we're in Utah. And filmed without permission using concealed devices. They refused to leave when directed, effectively trespassing. BAM contacted the Provo Police Department, initiated a report, and requested charges. During this December 2025 encounter at BAM's corporate offices, Schneider demanded $200,000 and stated that failure to pay would result in reputational harm and that matters would become very bad. We're circling back now, aren't we? BAM reported this attempted criminal and civil coercion and extortion to police authorities. I can understand why the police didn't take any action on that. This incident was incorporated as part of Provo Police Department case number so-and-so, regarding which BAM understands an investigation remains ongoing. What do you think about that? Do you think that saying things would become very bad is what? Criminal coercion and extortion?
Criminal threat. Yeah. Well, there's a reason the police in Provo are not in the news, right? And being scrutinized. I think they just sort of went,
Yeah.
Yeah. I think perhaps had that been said allegedly in American Fork, there might have been another outcome. But in Provo, they're not going to follow
You may be right. I don't know.
Yeah, I don't know either.
Say that legally speaking, if you said, I'm going to kill you unless you pay, you mofo, then that would be a threat.
That's probably true. It's interesting with the different police departments. Even the Salem, Utah Police Department has had to put out an official statement saying, we are not police connected to Salem, Oregon, where everything went down in Oregon, because they're receiving, some people are making problems for them. They're like, nope, we're Salem, Utah. We have nothing to do. I mean, people are really exploring this. Yeah, it's interesting.
Wow. Okay. Thank you for that. Shortly after Schneider's December 2025 BAM corporate office incident, Crystal initiated a second legal demand letter, right? That's her second legal demand letter, a year after the first one, on January 2nd, 2026, through a new Utah council, of course, after waiting approximately 13 months, whereby she reasserted her previous unsupported 1224-24 demand demand letter claims. BAM responded and again denied all allegations and provided evidence to rebut such. Under the franchise agreement, BAM proposed a face-to-face meeting, which was held but unsuccessful in resolving the private dispute. Once again, private. At some point, a judge looks at this and says, "Do you think I'm stupid? I
Yeah.
get the fact that you're leaning on this being a private dispute. You don't have to underline everything for me." In resolving the private dispute, in connection with which BAM proposed a full document exchange. I mean, maybe underlined it the first time, but every time. So BAM proposed a full document exchange at this meeting. Crystal and her counsel refused to produce any further records, including a signed copy of the 11/22/23 consignment agreement. So they would not produce that document, the signed document, between Crystal and Brian, apparently, and any inventory and payment records. That was a bust. Upon information and belief, Crystal informed Schneider of BAM's rejection of the face-to-face meeting. Oh, they rejected the face-to-face meeting because they said we don't have the documents, I think. And her renewed legal demand regarding the private civil matter. Thank you for underlining private again. In the course of BAM and Crystal's face-to-face meeting, they did have a meeting. And as a veiled threat to BAM, Crystal asserted that she and Benjamin could and would not stop Schneider's continued harassment and involvement as an alleged documentarian. Okay. Well, if they're not involved in the first place, I know they're saying they are, and it's the enterprise that they're all involved in. If they're not involved, then they got no legal duty to stop some but other third party from talking about them. BAM specifically raised concerns Crystal had improperly shared confidential information with Schneider and Brian in the meeting. Upon information and belief, though Crystal relocated out of the country for approximately a year through early 2025, she still engaged indirectly in the enterprise and in support of the unlawful activities described herein. The Kaiser police have informed BAM that she has returned to the United States and has been interviewed. In a 2/5/26 call, which may have something to do with why it took a year between those demand letters, because she was out of the country. In a 2/5/26 call with BAM as part of an attempted dispute resolution, Crystal and Benjamin threatened that if BAM did not pay their demand for $300,000, they would not be able to control the documentarian Schneider from releasing damaging and doctored videos harming the company. Now, the red flag that goes up for me in this is the placement of the quotation marks. Okay? Because all the quotation mark says, they would not be able to control the documentarian Schneider from releasing damaging videos harming the company, right? But they put it in the context of saying, if BAM did not pay their demand for $300,000, comma, then the quote begins. Do you understand?
Yeah,
the
no, I
condition
see
is
what
not
you
part of
mean.
the quote. The quote itself is not that remarkable. They're just saying we can't control this YouTube guy, Reckless Ben, from whatever he's doing. That's all they're
Right.
saying in the quoted part. But they're casting it in terms of that she said that unless you pay us the $300,000 that we're
Right.
demanding, then we won't be able to control it.
Oh, that's a good catch. That's the reason you're a lawyer. Yeah, because those two statements could have been made completely, one's kind of inferred, implied. One says it's directly in quote. Why do you think "and doctored" is in parentheses?
I don't think it's in there.
Yeah,
I
do you
think they
think
added that.
that's what I'm saying? I think they added that. That's exactly what I think. Interesting.
I think they doctored
The doctored?
the statement and put in and doctored.
They
Yeah, they
doctored the
doctored it.
doctored statement?
That's the irony here.
Yeah. No,
So
and
this extortionistic threat, see, if
yeah.
she really said it and it were that clear, they'd be
It
quoting
would
the
have
whole
been
thing.
all in quotes. If she said, "If you do not pay me 300,000, I will not be able," yeah, that would have all been in quotes.
Mhm.
The other part is implied, right? It's how they understood what she
Yes.
said, but certainly not in quotes. That's fascinating.
Yeah,
Wow.
these are the kind of
Punctuation's
things.
important.
It's not why I'm a lawyer, it's just things that you develop over time being a lawyer, seeing the things that are not said. This extortionistic threat directly evidenced their knowledge, conspiracy, aiding and abetting in coordination with Bryan and Schneider. I hope you have more evidence than what you have in that paragraph to support that allegation. Thereafter, Schneider and the Schneider Group and affiliates also initiated a series of fake lawsuits not properly served against fictitious entities to create fake bases for them, bases, plural of basis, right?
Mhm.
To create fake bases for them to deceptively claim they won a lawsuit in Schneider's published YouTube content, which was false and misleading and in furtherance of the enterprise. None involved BAM or Baker Salem legitimately. That legitimately word is doing a lot of heavy lifting there
Yeah, it sure
because
is.
obviously they involve BAM and they involve Baker Salem. They're
Yeah.
just arguing it doesn't do it legitimately. That's what I think. Okay, so that's the lawsuit aspect that they are responding to.
Yeah, there's a in this part, there's a lot of wiggly words that yeah. I am it's going to be so interesting to watch when Reckless Ben and his team puts together their countersuit and, addresses each of these points that the BAM suit is making.
Yeah, and I'm not sure what it means because, theoretically, if you were to file a lawsuit against somebody else, you have to have service, right?
Yep.
Okay. Served, not properly served. See that in there?
Yeah.
You have to have proper service, but they're saying no, they didn't properly serve them. So I don't know. I don't know what they're saying there. There's not a lot of details. I think we're going to find out when we get to the response. Do you have
Oh,
information?
well, no, I mean they claim, BAM claims, of course, or Josh claimed in the video that's now unredacted, that this process server, who in Utah apparently just has to be somebody over 18, right? And somebody
Mhm.
not affiliated with the
Not a
person.
party to the
Like the
lawsuit.
person that was with Ben had just met him and she was supposed to walk up, I've received papers like that, not for myself personally, but
Really?
for a job, at a job, somebody, yeah, thanks. Start a rumor. There you go. Rebecca's been served. No, but they kept saying this is not an official, this is a fake process. No, anybody can be a process server. Also, I feel like the police could have served them. All you have to do is kind of set them down and go, you're served, right? And it doesn't matter if the person wants to accept them or not. Serving means you've got them, right? So that was a very interesting video, and they're both BAM is
Mm.
claiming something different. So
This is thank you. This is a paragraph that's supposed to stand on its own. I think it's
yeah,
an allegation. It is clear that there is a lot more to this side of the story that they're not talking about. Maybe because it's already 95 pages and they don't want to go past 100. I don't know. There may be a limit. There
maybe
are
there is a
limits
limit.
sometimes. So, uh, thereafter, Schneider and the Schneider Group also initiated a series of fake lawsuits
Yeah,
not properly served against fictitious entities
yeah,
to create fake bases for them to deceptively claim that they won a lawsuit. There's like five things in that where they're saying this is wrong, bad, fake, not properly served, fictitious. And I'll look forward to seeing the response so we can see what
yeah,
the other side of that story is.
yeah,
And in furtherance of the enterprise, none involved BAM or Baker Salem legitimately. So there's a sixth one. On March 8th, 2026, which is a Sunday apparently, Schneider and the Schneider Group deceptively dressed up and impersonated federal employees in fake USPS or UPS outfits and approached Josh's residence in American Fork, Utah. This would be a different incident with the UPS
yeah,
outfits.
yeah,
They delivered a package containing undisclosed but humiliating items. Is this the rubber ducks?
yeah. There's nothing more humiliating than a rubber duck.
I always feel so humiliated when someone sends me a box of rubber ducks. I don't know why.
I love rubber ducks. I have like 100 of them.
Are they even going to say that there were rubber ducks in there?
No, because everything sounds like just kind of all in good fun, right?
Well,
Except
if you
for
say
when
it's
you
rubber ducks,
express
it's hard
it
to
this
say
way.
humiliating in
Yeah,
the same sentence, I guess.
yeah. I mean, you can turn anything. One time, somebody left a full-on toilet on my front porch. I had teenagers. I had teenage boys. It was a prank. Somebody was doing, am I going to call the police and say someone has left a humiliating item on my porch? No, I took it into the backyard and made it into a planter. Super fun.
I think you probably did the right thing.
I think so too. It was really cute.
I would have to think that a toilet on my front porch would be more humiliating to me. I don't know if it'd be that humiliating. It's kind
It
of
was
funny.
new. It was not a used toilet. It was a brand new toilet,
Oh,
but it was just
really?
appeared on my front porch one day, and we all laughed and took pictures and took it in the backyard and made it into a planter.
See, these are the kind of things that when you make these allegations without telling the judge the full story, right? And just saying
That's
it's a
it.
box of rubber ducks and my
Yeah, what's
client
the judge
considered this
gonna
to be
say? Can you
humiliating.
Yeah, the judge will go, "Can you please, define what is humiliating, Your
Mhm.
Honor?" Ducks.
Ducks,
I
rubber
mean, is that
ducks,
what's gonna
lots of them.
happen?
No, but you see, this is the thing, when you make an allegation like this and the judge finds out later, not from you, be
Yes.
better from you if you
Yes.
told the judge that it's ducks, and you go, "Oh, ducks." Okay. They delivered a package containing undisclosed but humiliating items and requested his signature on a device or form. Multiple vehicles were parked in front of the house with individuals filming the interaction.
Yeah.
Josh considered this to be another trespass. The reason
Yep,
they put
and you
Josh
could
considered
talk
this to
about, I mean, is it illegal to impersonate an employee of a company where you do not work? I don't know.
well, if it's a cop, it is.
Right, if it was a delivery person, I mean, I don't know.
I don't know. I don't know
Yeah,
the answer to that either.
yeah.
And I'm not sure if it is. Obviously, if they did a crime, then the crime would be what they would be going after, but
Right,
this is
right.
just delivery of ducks. Josh considered this to be another trespass. They put that there. Notice how they're even hesitant about that, about somebody walking up to a front porch,
Yes. Is that
putting
trespass?
something on the front porch,
Right,
having people on the street videoing. That's not a trespass, see? That's why they say Josh considered this to be another trespass.
right.
Josh reported this incident to the police, and American Fork Police Department responded by escorting the offending individuals from the property for trespassing. So they're escorted from the property. Were they on the property?
Boy, that's quite
They're,
a brief summary of what actually happened, and I'm sure you guys have all seen that video, so that'll be really interesting
yeah, they're parked
to
in front of
watch.
the house. I
Yeah,
would assume they're parked on the street, which would not be on the property
yeah.
or trespassing. Notwithstanding the police intervention at Josh's residence, Schneider thereafter began continuously calling Josh's phone number, further escalating the harassment and extortion attempts. On March 8th, 26, Sunday, same day as the duck delivery. And 1 hour after harassing Josh above, Schneider and the Schneider Group deceptively dressed up and impersonated federal employees in fake USPS or UPS outfits, so same modus operandi, and delivered a package to Brandon's residence in Sandy, Utah. So an hour later, they're at Brandon's, containing undisclosed but humiliating items and similarly requesting a signature. It's like they want the signature, isn't it?
They want the signature. Yeah.
Upon information and belief, as stated in Schneider's own video publications, the intent was to acquire Brandon's signature. It's like, I can see this in advance for use in additional fraudulent schemes. That's what
Yeah.
they're saying. Schneider admitted that, but I don't know if he said those words. Once again, there's a lot of things that are allegations and not necessarily factual in this.
Right,
Multiple
and
vehicles
if
were,
they did impersonate a mailman, like a postal service worker, that could be a problem,
I would think so, yeah, because that's
possibly.
government.
Yeah.
Multiple vehicles. Well, USPS, United States Postal Service,
Mhm.
that would be government. That'd be a mailman.
Yeah, that could be.
I believe that's what it stands for. Multiple vehicles were parked in front of the house with individuals filming the interaction. Josh reported this incident to the police. Trespass notices or warnings were issued. So I'm guessing no signatures were obtained. Doesn't say. On March 8th, 26th, Sunday, same day, right? Schneider and or the Schneider Group also appeared at the home of Jessica Johnson, which is Josh's sister. An innocent bystander not affiliated with BAM, residing in Pleasant Grove, Utah. Upon information and belief, they impersonated state police or officers of the court. Okay, so which is it? And falsely told Jessica they were investigators investigating a crime. How's that false? You see, this is the whole thing. If they say, we're here, we're investigators, and we're investigating a crime, And Jessica thinks that that means that they're state police officers
Yeah.
or officers of the court. That's why they don't know which one. She believes that's the case, but they don't say it. And if they don't
Hmm.
say it, then they're not impersonating one. Does that part make sense?
Yeah, no, that's interesting. So they don't represent themselves as those
Mhm.
entities, but the person they're talking to assumes and treats them that way.
Yeah,
And so now Bam's complaint is they were impersonating, even
right.
though
Well,
it's
they're
an
investigators.
assumption on a person's part. Yeah, and that doesn't fly.
If you're investigating something, you're an investigator, and they're investigating a crime. So
Right.
there's nothing that's wrong about that. There's nothing impersonating about that. You're impersonating an investigator. Well, you are an investigator, but you don't have to be impersonating state police or officers of the court if you just say we're investigators investigating a crime.
Right.
Now, what I'm doing here in a number of occasions, like in this paragraph, this basically is as good as it's going to get for the plaintiffs. This is their version of the case.
Mhm.
And we can see where they've kind of been fudging things in their favor in a number of places over and above what the facts that they're adducing say. This is another place where, just based upon their complaint, which is as good as it gets for them, I'm saying there are certain soft spots that I can identify just from the complaint itself. And this is
Mhm.
another one.
Yeah, and you're just reading it over. I mean, you have not dug in because you just got it this morning. So
Mhm.
I
We
imagine if
wanted to
you
get this out to people as fast as possible.
I just felt like we should, just because it is very interesting to see their point of view, and I'm guessing the counter one is gonna come out sooner than later, and then we'll wanna cover that too. So, but what I'm saying is with your expertise, you can spot these where the rest of us would just read it and go, "Oh, okay," but you can see it. You can see through it because 'cause you've dealt with so many of these.
Yeah, or related things. And I won't
You
go into
exactly.
the experiences I've had that I'm relating to this, but yeah,
Yes,
I'm pretty
yes.
sure that this is weak. This incident was reported, and Pleasant Grove Police Department responded. And if they just responded and that's the end of the sentence, they didn't do anything after
Mhm.
they responded. On May 9th, in other words, it's March, but in other words, if they had arrested somebody or anything, they would have put that here. On March 9th, 26, Monday, the following day, a member of Schneider Group again appeared at Josh's home pretending to be a member of his church congregation to lure him out of the house and to harass slash record him. The member informed police that he had been paid by Schneider to do so. He reported this harassment, and American Fork Police Department responded. Trespass warning was issued, and Josh told him never to return. Hmm. Well, they're saying that this guy, whoever it was, appearing at Josh's home, says that Schneider paid him to do so, but paid him to come to a house to record him. Yeah. Okay. Sounds like an employee employer relationship, or maybe just a contract employee, but I don't know
Right.
that that's necessarily bad. See, once again, all this depends upon what he did at the house. And did he really, was he really there to harass him or record him? And how do you know if he didn't get him, if it didn't work, right? He was sent there to lure him out of the house and to harass, record him, period. Means he didn't lure him out of the house and harass or record him. So how do they know? Well, they don't. They're assuming, they're alleging.
Yeah, and I think that's one of the videos where he says, I would know if this guy was in my ward. There is no Harbor Second Ward. I'm Harbor Eighth Ward. You know, I'm on the High Council. I think, which was redacted and
Very
now
good.
is available as unredacted. So,
Very good. So this guy says, I'm a member of your state because this guy was on the high council, as we all know now. So that's why.
right.
Member of the stake. And what ward are you in? Oh, I'm in this ward that doesn't exist in your stake. Hey, that word doesn't exist in the stake. That
Yeah,
makes
and that
sense.
would be very confusing to somebody that isn't LDS, how you can have in one stake harbor 1,
Mhm.
3, 7, 8th ward, and then in the other stake you could have harbor 2, 4. Do you know what I mean? It's
You just had the
very
wrong number.
yeah, and even what a stake or a ward is, it's all very confusing for sure.
Okay. Thank you. On March 10th, my birthday, Tuesday, Schneider and a team member visited Josh's house to further harass and engage in content creation, which was again reported. American Fork Police Department responded and a trespass citation was issued. That means they charged him with trespass.
Yeah.
Schneider was arrested on residential picketing charges, booked into Utah County Jail, and later released on bail. Okay, I'm guessing. Now, I don't know this, and I can't trust these people who are writing this complaint.
Mm-mm.
But there may be a provision in Utah law that says you can picket businesses, and that's fine, but you can't picket a residence, and it may be the same here, and I've just never encountered it in 36 years because it doesn't come up that much. Residential picketing charges, booked into Utah County Jail, and later released on bail.
Right. But again, all of this that you just read, we
Yeah.
had the footage and now we have the unredacted footage.
Yeah.
And if a judge reads this complaint and then, the defense attorney says, watch this, Your Honor, I think there's going to be a big problem because the
Yeah.
footage is very different, especially now that it's unredacted.
Well, that's going to be very, very interesting for the judge to do that. Interesting for us to find out what it is that they respond with.
Mm-hmm.
Because of course they're going to be given the other side of the story. And the problem is if
That's
I'm
it.
just looking at their side of the story and I see weakness, and kind of overstating,
Mhm.
that's
Already.
their version. Yeah, that's their version. Imagine how
Yeah.
bad it's going to be when the other side comes in and explains not only all the questions that this is raising for me, but additional stuff.
Right. And that's why it's important to read this into the record so that everybody knows what's being claimed. And then when we get the other side, we'll read, then you kind of juxtapose everything. But I mean, already knowing what we know in your mind, you kind of go, yeah, that footage is not, does not support what happened here. It's kind of like that.
Yes. The following day on March 11th, Wednesday, Schneider and the Schneider Group trespassed again to deface and hang a defamatory banner in Josh's subdivision in American Fork, Utah. So there was one. After it was reported, there was a banner at his house, apparently, in Josh's subdivision. That's not at his house. After it was reported, American Fork Police Department responded and a stalking citation was issued because he's been doing this repeatedly. Schneider and 4 others were arrested on stalking charges, booked into Utah County Jail, and released on bail. Yeah, because I immediately made the assumption that they wanted me to make that this was at Josh's house. But it's not. Otherwise, they would have said it was at Josh's house.
Mm-hmm.
It's in Josh's subdivision. That's what I take from that, which is not his house, right? On March 11, 26th, the following day, Thursday, Schneider and his team made an appearance at the Orem Bricks Minifigs location in Orem, where he disparaged and defamed BAM to customers before an employee removed them from the premises. The Orem Police Department responded. See, responded. And a trespass warning was issued. See Exhibit I. So, shouldn't have 2 responded there, but they're saying he went to Orem and badmouthed him there. Okay, so he gets trespassed from there. When I say trespassed as a verb, that means that a place like a store, like the Minifigs, was it Bricks and Minifigs? In Orem, Utah, any kind of store, they're open to the public, but if you go in there and you do something and you can be trespassed from the store. And usually it's done by police and they do it with a document. So it can be proven later on, but they don't have to do it with a document. They can just tell you're trespassed because the owner says they don't want you here anymore. And a store that is otherwise open to the public becomes not open to you. And if you go into there after you've been trespassed, then that is, you're committing the crime of trespass.
Okay, that makes sense.
Yeah. So trespass is used as a verb in that way. Trespass warning was issued on March 13th, Saturday. It's a busy week. Schneider and his crew appeared at the Bricks and Minifigs South Jordan store and began filming people and demanding statements and explanations from the owner and employees. This was reported to the South Jordan Police Department, which responded, and a trespass warning was issued because it's a different store.
Mm-hmm.
I would be wondering if corporate wouldn't want to send out some kind of trespass notice to them for all their stores, but we'll see.
Right.
Notably, on or about March 13th, 25, BAM had issued Schneider and the Schneider Group a formal written notice. They did. A formal written notice of trespass, harassment, and prohibition respecting any and all BAM franchisee locations. attached as Exhibit J. Despite this notice, co-defendants continued their campaign of harassment and destruction at multiple Bricks and Minifigs locations in Utah before moving on to California, where they similarly harassed other franchisee stores and employees. During these ongoing spring 2026 incidents, state law enforcement officers attempted to coordinate across state jurisdictions. On or about March 27, 26, Schneider was scheduled to appear before the 4th Judicial District Court of Utah, that's this court, where it's filed, regarding the stalking matters, and failed to appear. Upon information and belief, a warrant was issued for his arrest. Do you know anything about that, Rebecca?
I didn't know that. I did not know that. That's interesting. I thought I was up on everything, but no, I didn't realize that. That's
No,
interesting.
they're
I'll
saying
have
he
to
got
try to
cited for the.
find out more about that. Yeah. I
They're saying he
think
got. Go ahead.
somebody in the chat is saying that he was going to appear, but there were technical difficulties on Zoom, which happens. So it sounds much worse the way they're describing it, right?
Yeah, and look, when people don't have familiarity with the law, sometimes they'll look. You're supposed to appear. It's by Zoom. It's allowed a lot now,
Yeah.
especially since COVID, when it started becoming much more frequent. Usually, have to go to court.
Yeah,
But
because I feel like he would not on purpose not appear. He does that. There it is. He's complying with everything.
yeah, and sometimes, like if your COVID connection, your Zoom connection, whatever goes down, get on the phone. I mean, do you have an attorney? He has money, doesn't he? He's very successful, isn't he?
Yeah.
Schneider?
Yeah, he has a lot of people supporting him. A lot of people in the legal world have jumped forward to make videos and support him and give him advice. So, yeah, I think he has a lot of people in his corner.
Okay, so I don't know if he was supposed to be on Zoom or if he was supposed to be there present, but what they're alleging is he failed to appear and a warrant was issued for his arrest.
Yeah.
All right. So, for the future, if you're supposed to be in court and your Zoom connection fails, get on the phone and call the clerk immediately. If you don't have an attorney, let them know that it's your Zoom connection. You're not appearing on purpose. Further unlawful activities in furtherance of the enterprise, they're alleging 104, paragraph 104. Each of Schneider and the Schneider Group's foregoing and ongoing actions is an independent episode of unlawful activity in furtherance of the enterprise and conspiracy among co-defendants with Brian, the original consignment claimant, regarding his unrelated dispute with Crystal. Thank you for reminding us. Crystal and potentially their attorneys. Whoa, wait a second. Each of Schneider's foregoing and ongoing actions is an independent episode of unlawful activity in furtherance of the enterprise and conspiracy among potentially their attorneys. It's a big claim. I hope there's some evidence of that. Mm-hmm. They're saying they think their attorneys are involved in this.
Mm-hmm.
As evidence in this record, co-defendants very carefully planned their pattern of unlawful activity, which was known and coordinated by and among Crystal, Brian, and Schneider, including alternating public and legal actions. I mean, are they saying that their attorneys advise them what would be against the law and what would not be?
Maybe that's what it is.
I don't think that makes an attorney involved in what you do, but
right.
At least I hope it doesn't. Upon information and belief in thereafter, additional May 2026, it doesn't. I was just being facetious there because, of course, I've given that advice before. Would it be legal if I did this? That might be crossing the line. You might want to do this instead. That kind of thing. Upon information and belief in thereafter, additional May 2026 communications between Brian and Schneider and presumably Crystal, including public and private exchanges in which they have discussed an ongoing strategy to harass, intimidate, and pressure BAM and its franchisees' personnel, including as evidenced in Reddit threads, comments on publications, and other social media or electronic means. Representative image. See, this is their version of what's going on the other side, where they're going after them and trying to publicly expose and embarrass them for the wrongdoing they've done in order to get them to cough up the money or the Lego Star Wars sets.
Right.
Representative images and content evidence. Representative images and content evidence. Evidence is being used as a verb here. Evidence, content evidence. Never mind, it isn't. It's a noun. Content evidence of Crystal's engagement, both directly or indirectly, with co-defendants in Schneider's campaign are set forth below. Okay, guess what we're going to go to? The 5/21/26 YouTube video. So here they're going to try and say that this is the evidence that Crystal is involved. So minute 148 through 251 of that video, they say Crystal recklessly and without proof discussing and misrepresenting a private business dispute with Bam, sometimes known as giving her side of the story, while speaking with Schneider and further providing Schneider with security camera footage to aid Schneider and Schneider Group in producing the 5/21/26 YouTube video. Okay. Okay, so this must be Crystal on the left.
Right. Yeah, and they're talking. Yeah.
And here's another thing. There's Crystal on the bottom right.
Yep.
Okay. These being screen grabs from that video, the 5/21 video. And here's one. This is inside the store, I believe. That looks like Crystal in the middle. This must be some of that footage that they're talking about. Security footage. GoFundMe solicitation. You mentioned this before, Rebecca. Do you want to read this?
Yeah, it says GoFundMe solicitation. As recently as this past week, Crystal set up a GoFundMe account, as confirmed in her Instagram post, using the now viral hashtag #RecklessBen, among others, and stating that, and this is in quotes, "So my face has gone a little bit viral." And then she includes a link and a GoFundMe titled, "They took our Lego store and life savings. Help us fight back," quote. And then there is the link to the GoFundMe. So is
So
this just showing her connection to Ben, or
Yes.
that she's profiting from what he's doing? Because it's certainly not illegal to set up I've seen GoFundMe for
No.
crazy things.
No, what they're trying to do, and that's important that you brought that up. This is not necessarily so much supposed to show that she's doing things that are illegal. I think they're laying that mostly at Reckless Ben's feet, which they've done before. I mean, previously. And now they're trying to show that why she's a co-defendant along with him.
Right. Okay, that makes sense. And that goes to my question before. Why don't they separate these? They have nothing to do. They do in this sense, which is what you told me 3 hours ago.
Oh my Lord.
I should have listened.
Is it really?
It's okay. We're almost
3
done,
hours
everybody.
ago.
No, we're almost done. And
How are
once
there
it's
over
ready to the
500 people
record,
still watching? More and more people are watching
I-
this. How can that be
I
when it's been over
don't
3
know.
hours?
I don't know why they're not at work. I don't know why we're not at work. What is happening? But we are almost done. We're getting to the end because I don't think you're going to read through those case things at the end. So
I need to get into the Lego business. That's the work I need to get into.
I'm telling you, this is the only bad thing about Legos is when you step on them. Have you ever done that, RFM?
Yes.
Like your kids leave them out and you're walking. There is nothing more painful than stepping on Legos. Ugh.
I also stepped accidentally on a slug one night with no shoes or socks on.
Oh my God. Well, that's not painful. That's just very odd. Yeah.
That
Yeah.
was 50 years ago, and the memory still haunts me.
Did it die?
I expect so.
Oh gosh. I'm sorry.
GoFundMe solicitation. You already read that. Okay. So
I already
in other
read
words,
that. Yeah.
Reckless Ben is the hashtag. She's associated with Ben, right? My face has gone a little bit viral because of this whole thing.
Yeah.
So that's all that they're trying to do here, show that.
Yeah, and I checked the GoFundMe on Monday for the newscast when I was trying to give just a balanced view and scenario of everything that was happening, and it was up to 50,000 on Monday. I'm guessing it's probably more now since the other one is also more.
Can I do a minifigs GoFundMe?
Yeah.
They took my Lego store, so my face has gone a little bit viral. So that's from that clip. They took our Lego store and life savings, help us fight back.
Yeah.
So they're giving the images of what it is they've alleged before, which is always helpful.
Yeah.
If you have them. As of this one, it was $90,000 raised to $35,000.
Gosh. That's only in a few days. I'm telling you, on Monday when I looked, it was 50,000. Wow.
So that was probably around May 27th. It was signed May 27th, so it had to have been before then, but they probably wanted to make it as recent as possible to make the number as big as possible.
Yeah. I think they grabbed that and put that in. So, wow. Oh, somebody in the chat is saying 74,000 raised. So, I don't know, different numbers,
well,
but
90,000.
A hell of a lot of money. Let's just say that.
You can't take it away once you've raised it, can you?
No. So I'm not sure where that screenshot came from.
Well,
it's really small.
I
Does
think
it say 90?
This is supposed to be her personal, right? GoFundMe, and it's had 90,000 of 35,000 raised.
Yes, someone else. Okay, they say again now it's 90. Yeah. And I think that the other one for the Lego owners is 300,000 or more at this point. So,
By the
wow.
Lego owners, you mean the
Yeah.
man sells.
Yes, I know it's true. Lego owner means something different now, given that
That's what this
Ben
whole
wants to
case is about.
purchase them so that he can continue that, yes, the original Lego owners. Yes.
Yes. Okay. Thank you. Thank you. So two different GoFundMe's going on,
Yeah.
at least. Upon information and belief, Crystal deceptively has not disclosed the true nature of her private dispute with two. I'm guessing a W is missing from that TO. I think that's supposed to be the number two. With unwitting GoFundMe participants as detailed herein. Otherwise, the two should not be there at all.
Okay.
It's one of those things where you're going through and you have with unwitting GoFundMe participants and you think that two is probably better. And then you put the two in and you forget to take the with out.
Okay.
But all they're saying is they're alleging Crystal deceptively has not disclosed the true nature of her private dispute with unwitting GoFundMe participants as detailed herein. So what they're saying is she hasn't told her GoFundMe donors the real story about how she's the one who's responsible for this.
Well, that's very interesting because she told her real story. So it's up to an unwitting participant to try to decide, where they fall in the spectrum of belief. That's that's really funny. Ah,
The publication's false accusations, ongoing damages, and irreparable harm. The publications, which is generally the videos, especially the 52126 YouTube video and the videos by Reckless Ben, repeatedly and falsely defames and accuses BAM, its corporate leadership, including Ammon and Matt, franchisee operators, store employees, and local police, of theft, criminal conduct, corruption, and a cover up. Specifically, the video opens by stating that a Lego collection worth approximately $200,000 was stolen and that the thief is BAM. The video further falsely states that police are actively working with the thieves to cover up the matter. These accusations are defamatory, false, misleading, and unsupported, as the matter characterized in the publications concerns a private disputed store-level consignment inventory issue. They're going to rehash their argument that it's a private thing between the man sells and the original franchisees. Okay. Crystal and Brian. At an independently owned and operated franchise location, Salem LLC, not an adjudicated corporate theft by BAM. No court or law enforcement finding has established that BAM stole or wrongfully converted any property or participated in any police cover up. Okay. So basically, if Reckless Ben did say this in this video, and it's true, then he's in the clear on this allegation. If he's not, he may not be. And that's why the evidence here is going to be very interesting, because the evidence is actually going to go to whether these allegations are true.
so they have to solve the crime. They have to solve the mystery in order to decide. I mean, they have to figure out where the Legos are.
Well, I think that for Ben, he has to show that he wasn't being misleading or unsupported, that he
Right.
genuinely believed it. And here's the evidence on which, he was looking at in order to
Exactly.
support that belief.
Yeah.
So, yeah. As recorded in the 52126 YouTube video, Schneider directly confronted Ammon, the CEO of BAM, falsely representing and stating, "You took the Legos," asserting he is lying and stating that Ammon was in on this cover up. Video evidence of this confrontation is included in Exhibit C. Yeah, if there is no cover up, this would be wrong. This would be defamatory harassment. I expect for Schneider to be doing that. If there is a cover up, then he's just telling the truth and trying to get to it. The video does not confine itself to commentary. It depicts and promotes repeated in-person confrontations at BAM stores and corporate offices, including visits after personnel asked Schneider to leave, police involvement, trespass warnings and or citations, covert recording, attempts to obtain employee and owner information, signage and branding stunts, obstruction of customers, and pressure tactics intended to force Bricks and Minifigs to act outside normal legal processes, i.e., fork it over. Evidence of this is included in Exhibit C. In the video and podcast, Schneider repeatedly threatens BAM, stating as an example that he will do whatever it takes. See, at this point, you start wondering, why did you take 95 pages? Because really, you're starting to repeat yourself now.
Exactly.
Schneider repeatedly threatens BAM, stating as an example that he will do whatever it takes and that he will stop at nothing in the campaign to extort monies from and to harass, bully, threaten, and assault BAM and its personnel. Of course, Schneider would have a different way of framing that.
Yeah, and that's another example of what you said. Those things are in quotes, and then they sort of infer the rest of it. So that's interesting.
Yeah.
To
The rest
them,
of their
he
argument.
means extort money and harass.
No.
Who knows? He said it in a different context. Whatever it takes, stop at nothing to get the Legos back for the old man.
Yeah, that you stole.
They're
That's his
inferring.
point of view.
Yeah, it's a point of view. That's what I'm trying to say. Yep.
And the facts will have to be figured out in court. He, which I think is Schneider, he frames BAM's response options as either responding with the extorted payment, i.e. the easy way, or continued assaults, destruction, and damage of any and all kinds, i.e. the hard way. Can you see all the interpretation that's going into this?
Yeah.
All he says is the easy way or the hard way, and this is how they interpret it. Well, that's not what he said. That's their interpretation.
Or they would have quoted it, right? If he said it specifically, the hard way means I will continue to, and that's all in quotes.
Yes.
But that's not in quotes.
He just says the easy way or the hard way.
Yeah.
And the hard way is frequently legal action.
There you go. I used to say that to my kids all the time. We can do this the easy way or we can do this the hard way. And they didn't ever know what that was, but it sounded not good.
Were they worried that you might have continued your assaults, destruction, and damages upon them?
Oh, I did that every day. Yeah. I had all boys. You had to. That was the only thing you could do.
Oh, and by the way, that's something that will be argued, of course. If he's been doing these kind of stunts leading up to this, then the hard way could naturally be interpreted as continuing to do what he's done.
Yes.
And maybe up it some. So context does matter. He further threatens that BAM deserves to have its life ruined. Does BAM have a life? It's a company, right?
It's an entity. So yeah, it can outlive any human being. That's for sure.
Under the law, a company is a person, but I'm not sure it has a life. He further threatens that BAM deserves to have its life ruined and describe plans to engage in intentionally provocative and even illegal acts to force litigation or further public pressure. Okay, that's how they're characterizing that video at the 26-minute mark.
Okay.
But once again, the parts that they are quoting are the best parts they can find from the video. Of course, you're going to quote the best parts for your argument, right? And from this video, really all they have is whatever it takes, stop at nothing. You can do this the easy way or the hard way, and BAM deserves to have its life ruined. In the publications, Schneider even goes so far as to incite and solicit BAM employees to act as undercover agents, stating he needs a Utah criminal defense lawyer and intends to take the entire corporation down. These incitements and solicitations have created and continue to create a substantial risk of unlawful harm, injury, damage, disparagement, defamation, public and private nuisance, i.e. disturbance of the peace, harassment, intimidation, unauthorized access, employee manipulation and abuse, and business interference and disruption. Any comments on that, Rebecca?
Nope. I think they're just kind of saying the same thing over and over again.
This part seems new because what they're alleging is that he's asking BAM employees in his videos to serve as undercover agents to get information for him, I think. So I see that part is new here, at least.
That part is.
Though unsupported by court records, Schneider publishes the false and defamatory claims that BAM lost in court and that a default judgment proves liability. Stating we win by default. Okay. This is something I'd gone down before because I thought this was probably what happened, and then I didn't because I didn't know, but now I will. Rebecca, if you file a lawsuit against me, I have to respond within 20 days up here, okay? Which means I have to file a written response and serve you with a copy, and then the lawsuit proceeds. If I don't file a response, then that means you can get a default judgment against me.
So I could say I won a lawsuit against RFM.
Yeah. So the thing is that you have to serve me. And then if I don't file a response, then you can petition the court and you file a response. You file a motion for a default judgment. You have to get that to me as well. And then usually 9 times out of 10, before the default judgment date of the hearing shows up, then the person files their answer anyway, and the default hearing goes away, and then the case proceeds. But if all that happens and I never file an answer or a response after you served me, so you've got proof that I know about this, right? That's why it's important. Service. You can get a default judgment against me, and that means you get from the judge everything that you asked for in the lawsuit. So that's why service is so important. And if you were to do that and I didn't know about it because you didn't serve me, but you represented to the court that you had, and the court entered, I mean, that's why there's supposed to be a document that's a proof of service, which is signed by the person who actually serves the thing. That's why that's an important document that goes in the court file, the original, to prove that service was accomplished. And if I don't respond and there's proof of service in the file and the proof looks good, then the judge will sign off on the order of default. So that's why it is very important to make sure, if you're the judge, that before you sign off on an order of default, that service was actually accomplished. That's all. Otherwise, it wouldn't be fair.
That makes sense.
Okay. So this is what they're saying. Though unsupported by court records, Schneider publishes the false and defamatory claims that BAM lost in court and that a default judgment, see, I figured it would be a default. A default judgment proves liability, stating we win by default. So something happened with the service and the response, because apparently there was no response. Otherwise, there would have been no default judgment. So that goes to service. That he may somehow seek a default is not a final default judgment. That he may somehow seek a default is not a final default judgment, enforceable judgment, or an adjudication of theft. Further, after Schneider made these public claims, BAM discovered multiple fraudulently filed Marion County, Oregon small claims court filings against Josh, citing erroneous entities and filed by false or unrelated parties. All of these filings made in January 2026 were dismissed by Marion County, which is what you should do as the judge, and a county sheriff's report was filed regarding the fraudulent filings. An additional Marion County filing was made by Schneider in March 2026 and is currently pending dismissal. All right. Do you have any questions about that, Rebecca?
No, again, this is why there are so many twists and turns. And I saw somebody say there's so many podcasts out there where people are dealing with this, lawyers like you, people weighing in. And this person said, everybody has like 8 out of 10 of the facts, or the story's straight, but they're missing 2, and everybody has a different set. It's very hard to find anybody that can put all of it together because there is just so much. There are gaps in our knowledge. And reading through a document like this, which again, for those who are joining late, is the claim, the
Very
suit
late,
from
I might add.
BAM. Very late. That's right. You only have like 10 minutes left that you can. But no, it's an important way to put it all together as far as what BAM claims happened. And then we'll see the things that a lot of us have seen put together by the legal team of Reckless Ben, and we'll see each one of these addressed. We're addressing them ourselves kind of here and in the chat, very light, right? We will really
I'm just doing the court stuff.
Yeah, that's right. That's all we're doing. We're just
I'm not here to advocate for either party.
No, exactly. And that's because you're a lawyer. You're in it for yourself.
I'm just trying to be objective, as you know. Further, after Schneider made these public claims, okay, so what they're alleging is using the court system in order to harass by filing harassing complaints and things like that.
Right.
They're saying they're baseless. And I think this has to do with a lot of the background on why it is that a default judgment was issued. And the claim is that that's what Schneider is referring to when he says, we sued, they lost. Okay, we'll find out more about those later, I'm sure. By the way, if you want to know this, there are times when people, I'm not saying that Schneider, Reckless Ben did this, okay? That's an allegation. But there are times when people do use the court system to harass other people, believe it or not, by filing harassing lawsuits that really don't have
Mhm.
basis.
Oh, yeah.
And so if a person does that, and it's a pretty high bar because they want to have people be able to file lawsuits, they want to have access to the courts for people to seek redress. So it's a high bar of proof. But if it comes to
Right.
the point where it's obvious, even to a judge, sorry, that a person is using the court system
Even to a judge.
not for the basis of advancing legal or valid claims or even colorable claims, but just to harass somebody, their name goes on a list. And that list
Really?
is at the clerk's office. It's like when you go to the, I don't know, Safeway and you see those lists at the checkout stand of the people that they're supposed to call the cops if they show up or
Oh,
don't
yeah.
take check from
The
this person.
picture
Or
behind the yeah.
that's that kind of listing. If this person
Wow.
files a complaint, they don't get it doesn't proceed.
You just lose your ability to be able to use the court system. Is that what
Not
it is?
completely, because that would be too
I was gonna say, that
what
sounds not great either, but yeah.
what ends up happening is they're on a list that says that before the clerk allows this thing to be filed with the court, a judge has to do an independent review of it
Uh,
and say it's okay.
so it still takes time. It's still bureaucracy. And in this case, as you know, and somebody reminded me in the chat that, individuals purchased, the missing sets and then filed their own small claims. So there were multiple small claims that were being filed by individuals. So he was using the court system, just to try to show, look, we need to get these back.
Oh, I see. Well, small claims court, once again, that's over there in district court. It's where they do
Right.
the misdemeanors. It's not where they do the big
Right. And it's
cases
very
or the
quick.
felonies.
Yeah,
And
that's why they did it because it could happen really fast.
the other thing about small claims court is that no attorneys are allowed.
Right.
It's like Judge Judy or one of those
Yeah,
shows where there's no attorneys.
that's
No
right.
attorneys are allowed because it's for small stakes kinds of things,
That's right.
small stakes claims as far
Like
as
under
value.
10,000 or something like that. It was some small number. And I think that's why they did that.
And that is why, I mean, especially when there's no attorneys involved, even so, a judge, look, judges make mistakes. They're human. Okay. Most of them are, but they can make mistakes too. But especially when you're dealing with non lawyers, you're dealing with lay people bringing lawsuits. And one of the first things they got to do is serve the opposing party. There's all sorts. You get an idea of how complicated that is, and I barely scraped the surface about service and how important it is. And you have to serve the right party, okay? But it is much more likely that service is going to get screwed up in a small claims court when it's being done by non-attorneys than it is by attorneys, and therefore judges in small claims court should be very focused in on that issue.
Right.
Is there a document in this court case that swears under penalty of perjury that I, the process server, whoever that is, served this document on this person on this date and time? That's what they need to be focused on.
Yeah.
And if they're not, then they could enter a default judgment. You can't enter a default judgment unless the other party's been served. That's what I'm talking about. Okay? Or are you about ready to get this thing done? We're on page
I
55,
think
but
we're almost done. Yeah, like I said, we're
uh,
taking one for the team. We're reading it into the record. Here it is. Hopefully people can refer back to it if they want to read through it. But
yeah.
yeah, we're doing it. Let's do it. Let's finish it.
All right. Incitement and solicitation of additional and or third party death threats. Oh my gosh. Death threats. I wonder if these are more I wonder if these are deathier than the other death threats they talked about. In other words, the death threats they've alleged before didn't sound like death threats. On or about 5/21/26, and in furtherance of the conspiracy, and following publication and online amplification of Schneider's false accusations through the publications, the videos, the co-defendants directly or indirectly solicited, incited, and or caused BAM and its associated franchisees and or personnel to receive death and bomb threats. Really?
Hmm.
These threats have been reported to relevant local law enforcement agencies and the FBI. True and correct copies of various threats toward plaintiffs is attached as Exhibit K. Okay, they're going to give an example. Good. These threats have been extremely concerning and personally and collectively damaging to BAM, its franchisees, and all personnel involved, prompting heightened security measures, lack of productivity, increased business and legal expenses, and a significant distraction of management and operations. Okay. For example, immediately following the publications on 5/21/26, remember that video? BAM received the following threatening email from F yourself, youclowns.com.
Sorry.
That's not funny.
No, it isn't
Stating,
funny, actually. I mean, seriously, being, yeah, go ahead.
well, okay. Okay. Let me just say what they're saying here. I got a corporation with Frenchies, and our specialty is messing your shit right up. Would be a shame if you, Fox, got a visit from one of my Frenchies owners because I just can. I think it probably would have been can't because I just can't control what they do on the Frenchies level. I heard they leave the place quite messy. Hope your dickhead CEO is a strong boy. Usually you would lead with your strongest piece of evidence. I'm not sure I see any death threat or bomb threat there. Maybe it's coming. Do you see it there?
I mean, maybe I don't understand all the phraseology there. Maybe words mean something that they don't mean or that I don't understand. But if this is the strongest thing they're putting there, it's definitely a subtle threat, maybe, right?
Yeah, it's so subtle it may not rise to the level of a threat at all. The other thing is this. If we put out a video, Rebecca, and we do several times, we talk about, let's just talk about Wade Christofferson, okay?
Right.
Somebody listened to our video. Let's say we were the only people talking about Wade. And somebody listened to it. And because of that video, they went and wrote or made a threat to Wade Christofferson. Let's say it was a real death threat, okay?
Yeah.
We're not responsible for that. We're not legally liable for what somebody does if they're crazy and they hear our podcast.
Thank goodness.
If we were inciting and encouraging it, that would be a
That's the
different
thing. If we said everybody go right now and this, and I think we have never said anything like that. But you're right. You do have to be responsible. You do have to think about those things.
Okay.
But does it stop you from presenting stories? Does it stop you from talking about, things?
Right. And to make this work, they would have to allege that Reckless Ben was soliciting this kind of thing. It'd have to be a threat in the first place. But it would also have to be that Reckless Ben is soliciting this. And I'm not sure that they have alleged that specifically. They made the allegation about asking for employees of BAM to be private, like investigators or spies, or give him stuff. I don't recall reading an allegation that he was asking the general public that was listening to his videos to threaten or harass.
Yeah, I think most YouTubers understand that would be really irresponsible to do something like that because people are already going to do that. I've seen things, hey, I've got so-and-so's address. Hey, in this case, right?
And whenever we've talked about a touchy subject or almost any time on the news, we'll go out of our way to say, we're not asking, we're not encouraging anybody to do anything about this. In fact, it would be wrong for you to break the law to do anything in self-help.
Yeah.
So I don't know. I don't know if he did or not. All I know is I didn't see an allegation of it before this, and I'm not seeing a threat here either. What is Frenchies? Do you know what Frenchies is?
I don't. I'm afraid to Google it.
Why?
I mean, there are dogs that are called Frenchies. People are probably laughing at us right now.
What's it
Boomer
like?
podcast. They don't know. They're both over 60. I'm going to Google it right now. Oh my God. No, I'm kidding.
Frenchies, handcrafted premium wallets and backpacks. Frenchies and Company.
People who are from France? A bulldog. Yeah, that was the number one. That's what I thought.
Frenchies can refer to several well-known brands, ranging from premium nail care salons to dog breeders and pet supply companies. So they have different names. I mean, these different companies apparently have the same name. But I don't see anything like a bomb manufacturer in here, anything that would make this particularly threatening. Let me know if you know anything more about that in the live chat.
Yeah, I'm going to have to look that up because I'm sure it's something really obvious that we're going to be made fun of for. So I'm ready for it.
I wonder if it's the dog breeding. I heard they leave the place quite messy.
Yeah.
Okay.
Somebody in the chat is saying, are they trying to say franchise?
Well, that's and I don't know, but I know that when
My
I put it
franchise?
in,
Maybe they have a French accent. My franchise owner? Maybe. I'm
well, on
sorry.
my Google, when I
I'm
put
low
in
blood sugar
Frenchie's
right now,
company,
5 hours later.
when I put
Yeah,
in
I don't.
Google Frenchie's company, it comes up. Did you mean franchise company?
Yeah, one of my franchise owners, because I can control what they do on the franchise level. Yep, I think that has to be it. But that's really embarrassing that they spelled it that way. If you're going to
Well,
send a death threat, you've got to get it right. Sorry.
you will
That's
be
terrible.
judged
It's
by
very
your spelling
serious.
and your death threats. And this is not a death threat. Okay,
No.
so let's read it again with franchise because I think you're right. I got a corporation with franchises like you do, right? And our specialty in our corporation with franchises is messing your shit right up. Would be a shame if you, I don't think that's franchises there, got a visit from one of my franchise owners because I just can't control. I just can control is really what it says.
Yeah.
I think it means I just can't control what they do on the franchise
Right.
level. Okay, so in other words, he's using this argument. If you're saying that you can't control what happens on your franchise level out there in Oregon with this guy Star Wars Lego,
Right.
then I'm going to tell you I own a franchise and I can't control what my franchise owners do to you. I heard they leave the place quite messy. Hope your dickhead CEO is a strong boy.
See, and I think that might be, as somebody's pointing out in the chat, the threat. Your
What?
CEO, he better be able to handle this because we're going to do something. I think that line might be the most threatening line out of all of it.
Okay, I think the most threatening line is that they're
Or
going to make a mess.
leave the place messy. Messy.
Which is not a death threat, nor is it a bomb threat. Let's go on. Let's see. They must have a real death threat or a
We
bomb
spent
threat
so
in
much
here
time
somewhere.
on this. I'm sorry. We're spiraling. Oh my God.
A
We
true
got
and
to
correct
finish.
copy. Okay.
There's another podcast coming up in 2.5 hours, right? On the same topic. So you guys can spend all day
Oh my gosh,
immersing this
yes.
if you want.
Yeah, and compare and contrast.
Yeah.
On
No,
the
it's
same
fantastic.
day, 521, immediately following the publications, that video, remember, 521 video? Bam received
Uh-huh.
another threatening email from the same guy. I think it's the same guy. Is that the same address? No, this is fuckyourselves@uclowns.com. This is clown@fuckyourselves.com. Obviously, completely
I'm
different person.
sorry. I'm trying not to laugh. It's just I
I'm
would
sorry.
be really scared if I got an email from somebody with that. I'd go, oh my God, we got to take it seriously.
That's because you're scared of clowns. Okay. Oh, I will be mailing you guys some explosive Lego sets. Okay, so there's at least something that explodes.
Okay.
Super hot items about to go boom. Your CEO Ammon is 2 days to step down before random stores going to get fun packages. You've been warned.
Okay. That's more threatening.
That's getting much more close.
Yeah. And that gives a demand.
Also, Lego set.
Step
Super hot about
down.
boom.
Yeah.
I'm sorry,
Step
what?
down. It gives a demand. Step down, or this will
Yeah,
happen.
that's
So
certainly
that's
getting
it.
closer.
Yeah.
That's getting closer. A true and correct copy of this email is included in Exhibit K.
Yeah.
So even if that's closer, and even if the judge were to consider that a true threat, they still got to make the link between this clown at fuckyourself.com
Right.
and I'm sorry, Reckless Ben instigating it in some way. All right. So these threats and ongoing harassments have caused immediate and irreparable harm to plaintiffs. They're going to say all the same stuff about all the stuff and how they've been harmed, including plausible risks to employee safety, franchisee safety, employee and customer safety, business interruption, reputational injury, increased security costs, store disruption, management distraction, and fear among personnel and their families. I'll tell you that first one, assuming that it is correctly worded here and contextualized. That first one, I don't think I would be worried about. The second one, I might be worried about if I got one like that.
Yeah. No, the first one with Frenchies, that just throws that just throws it all off. Oh my God.
I wonder if they were doing the same search. What the hell's Frenchies?
I bet it was like, word replace. They were typing it and then it just replaced franchise with French. I don't know.
Yeah, this one is getting pretty close to it. These threats. Okay, I read 121. Yeah. BAM continues to experience ongoing serious adverse impacts, including. Oh my gosh, we know all this. This really could have been 50 pages, you guys, if you had just
Oh
not
my gosh.
repeated
If
yourself over and
only.
over and left this stuff. This stuff goes in the complaints, the causes of action stuff at the end. All the ways that you've been damaged. That's where it goes.
Right. And again, they're not saying with all of those threats Ben sent them. Somebody watched this video of their own
Right.
volition, decided to do that. That's an important distinction. Ben did
Mhm.
not send a threatening
Yeah.
Frenchie text or email.
Which is why I say they got to show not only as a threat, but that reckless Ben was involved in it
Right.
in some legally liable way.
Right.
All right. As evidenced in the 5/21/26 Patreon video and publication, Snyder made additional statements in pertinent part using hate speech and religious bigotry. But it was about the Mormons. And inciting followers to also engage in hate speech, which many did, as evidenced by Exhibit K. That's going to be an interesting point. Did he incite others to engage in hate speech? See, at this point, there are times, okay, when you read a complaint, when an attorney is hewing closely to the facts, the one who files the complaint and documents everything, and as you're reading it, you begin to understand that this person who writes it has credibility. And because they're so credible on so many things, it tends to make you believe things that may not be so cited, right? On the other hand, when you have a complaint that's filed by an attorney who is so loose with the facts, then it makes you question everything the attorney says in the complaint. So when he says Snyder made additional statements in pertinent part using hate speech and religious bigotry and inciting followers to also engage in hate speech, unless you're going to quote that, cite that, show it to me.
Yeah.
I'm going to bracket that. I'm not going to take that as true, which many did, as evidenced by Exhibit K. Okay, so why aren't you quoting Exhibit K? You quoted the hell out of other things, right? Why aren't you quoting that here? Why are you just saying, hey, judge, this is what's in there. You go find it. It makes me think it's not there, or at least not the way they've represented it.
Yeah, I guess we'll see.
Can you do 123? Can you take on just for at least a little bit? Can you see it well enough,
You
Rebecca?
see, yes, I know. Let's see. Monetary damages alone cannot remedy bomb, death, and other threats or the risk of copycat harassment against employees, franchisees, not
Oh.
Frenchies, customers, or their family members.
Oh, this is where they're going to say, we want an order right
lot.
now. We want an injunction right now, a preliminary injunction.
Yep, I can keep reading. 124. Schneider's false statements constitute defamation per se because they accuse plaintiffs of committing crimes, theft, criminal conspiracy, fraud, etc., which are statements actionable per se under Utah law without proof of special damages. What does
Yes,
that
as long
mean?
as they're false.
Okay, as long as they're false. That makes sense.
In other words,
Schneider's
if I call you, if I say that there's a lot of question about what constitutes defamation.
right.
And the jury has to decide, or a judge has to decide, you said bad things about this person. Does that really constitute defamation? Was it bad enough? Well, there's an area of the law that if you accuse someone of committing a crime, then that's defamation per se, which means nobody has to make that decision. It's already in the law.
Okay.
That if I were to accuse you publicly of robbing the First National Bank, and done in a serious manner, that would be defamation per se. We don't have to have anybody rule on whether it's defamation. It is
like
defamation.
automatically. That's automatically
Yes.
it could be a defamation charge if I could prove that you did say that I robbed the bank.
It's sort of like running into a car from behind.
Mm-hmm.
Um,
Oh yeah, it's always your fault. It doesn't matter if they stop short. Doesn't matter anything.
and there may be just hyper technical exceptions to that rule.
Yeah.
Which there always are to every rule in the law, it seems.
No, I get
But
that.
that's
So
the
that
main
makes sense.
thing. It's liability per se. The person who runs into the back of another car, you're liable. It's not a question. It's not an issue for the jury. The only issue is how much do you have to pay because of your liability.
Right. But again, if Ben can prove this through video or audio or anything, then it's not defamation because he's literally saying this happened. Here's my evidence.
Yeah, so that would be like me, somebody suing me for running into the back of their car and me saying, okay, but that wasn't me driving.
And then you prove it.
Right.
Yeah.
Yeah.
Okay, that makes sense.
Okay.
All right, 125. Schneider's false and defamatory statements that plaintiffs are thieves who, quote, steal from old people, close quote, were published with knowledge of their falsity or with reckless disregard for their truth or falsity because Schneider knew or should have known that the underlying private dispute was a civil consignment matter at a single franchise location, not an adjudicated corporate theft. Okay, that's interesting. So he should have known all the things that he dug up that pointed to something else. He should have known that wasn't real. So he should have made the threat or shouldn't have made the accusation.
Right. So, I'm sorry. I was looking up the spelling of thieves.
Oh my gosh.
Thief is correct.
Yeah, it is. I know. I didn't know what you were talking about, which is why I was silent because I'm like, what is he trying to say?
You should have corrected me. So it just looks weird.
It does
But
look weird.
that is correct. IEVES.
That's right.
So,
We'll redact that part.
Schneider's false. Yeah, we'll go back and edit that out of this live stream. Schneider's false and defamatory statements that plaintiffs are thieves who steal from old people were published with knowledge of their falsity. Really? See, he has to know that they're false. That's part of the allegation they have to prove.
Right.
Or with reckless disregard for their truth or falsity. Right. Because Schneider knew or should have known that the underlying private dispute was a civil consignment matter at a single franchise location, not an adjudicated corporate theft. That's what they're going to have to prove. Why should he know or should have known that?
Yeah,
in other words, he should have known that we're innocent.
Yeah.
He should have known this wasn't BAM doing this. Was one of our franchisee operations.
Exactly. And I feel like they'll be able to show, Ben will be able to show that perhaps there were some tip-offs to law enforcement or things about stolen Legos. You know, there were some accusations that I don't know if they have proof of this that may have come from somewhere else, you know, that got them in trouble as they were here in Utah. So we'll see. We'll see. They could come up with their own, hey, these guys told lies about us in their suit. Hard to prove, maybe.
Oh, you mean a countersuit for defamation?
Yeah, countersuit. Yeah, that's what I'm saying. They could say, guess what? BAM or people associated with BAM told the police this or told the police that, and that, you know, resulted in us getting arrested, or, you know, somebody told the police that there were stolen Legos in their Airbnb, right? Somebody said that. Was that someone associated with BAM? We don't know. I would think that might be something they brought up.
Yeah, indeed. So it's going to be interesting, the counterclaims as well as their response to this.
Yeah, all the video, everything's going to be revealed with the video for sure.
Can you go on just a little bit longer, please?
I can. You reread what I read, which was odd. Okay.
Oh, that's because thief.
That's because you were looking at your, you know, writing. Yeah, thief. Okay. We are almost done, everybody. Hang in there. I personally need like an iced coffee and a lunch. So if anybody wants to DoorDash that to me, that would be great.
Just go ahead and give us your address. What's your address?
I know. You have to just kind of figure out and then send it to me. So, okay. 126. Schneider's conduct is repeatedly and brazenly trespassing and stalking plaintiffs at plaintiff store location and private residences after being repeatedly warned to leave and continuing to return despite trespass warnings from multiple police departments constitutes trespass under Utah law.
Yes, it would. This should be in your causes of action. Guys, come on.
Yeah.
Would you stop doing this? Stop repeating yourself and putting this in the wrong spot. This is supposed to be where the facts are. Okay. Not the argument, not the allegations.
And making us go on and on. 127, Schneider's use of the, again, we steal from old people, close quote, slogan, website, and merchandise in connection with the BAM brand undermines, tarnishes, and damages BAM's brand. That is really hard to say. Try it. And unlawfully associates the famous BAM brand with unsavory and negative qualities.
Yes. And the question is, did Schneider do that? Or did the BAM brand do that? Or did BAM do it to its own brand?
Interesting. 128.
Oh, go ahead, please.
Oh, I was just going to keep reading. The co-defendant's misconduct has presented plaintiffs in a false light before the public by portraying them as criminals, thieves, and exploiters of the elderly, which portrayal is highly offensive to a reasonable person. There's that key phrase, and was made with the knowledge of or the reckless disregard for the falsity of the publicized matter.
Mm-hmm.
Okay. That's pretty clear. 129, the co-defendant's misconduct evidences a pattern of harassment under Utah Code 765106, including following, monitoring, surveilling, threatening, or communicating to or about plaintiffs and their employees in a manner intended to frighten, intimidate, or harass. 130, the co-defendant's misconduct evidences a private and public nuisance. 131, Schneider's deceptively constructed and contrived raffle theory. This goes back to the raffle, asserting that Baker Salem failure to hand over a Lego set. And again, that was to make it a criminal matter, right? Because it's criminal if you do not hand over, something's won in a raffle. So they were trying to find a way to get it, I guess, bumped into criminal court. Anyway, to hand over a Lego set converted the matter into a criminal offense requiring police investigation is a fabricated and sham claim. This manufactured confrontation was deceptively designed to create false content and images for online viewers to generate profits, to falsely justify misleading criminal accusations, and to wrongfully invite police responses for additional content creation purposes. Yeah.
Okay.
And 132, plaintiffs have demanded co-defendants preserve all evidence, including specifically in Schneider's possession, custody, or control relating to these matters, including all of videos, raw footage, outtakes, communications, texts, emails, Discord, Patreon posts, YouTube comments, analytics, phone records, call logs, police communication and documents, now unredacted, right? Relating to BAM and the Lego collection dispute, threats, and creation promotion of the video. I'm going to say, bam, we did it. There it is. Because I don't think you're going to go into these causes of action.
Now, I'm not going to read through them. I'll just read the highlights because, and I'll say once again what they are, because a number of people have joined us since the beginning, and it's hard for me to remember back that far. Actually, we've been going so
hours
long.
ago. I'm not kidding. Hours ago.
So what they're saying here in section 132, it doesn't mention polygamy, but paragraph 132. Plaintiffs have demand. This is what they're saying is that they have sent to the co-defendants a demand for now I can't remember it. Basically saying don't destroy any evidence, preservation of evidence demand, and they're memorializing that in this lawsuit, paragraph 132, saying we sent this to them, saying don't destroy anything, preservation letter, preserve all evidence. Okay, then there's the first cause of action. Once again, they got a number of causes of action. This is where they're saying this lawsuit is grounded in law. In other words, you can't bring a lawsuit against somebody unless they violated the law. That makes sense, right?
Yes.
So these are the laws that they're claiming they violated, and they're called causes of action. So the first cause of action is a RICO, Utah RICO cause of action. And all they're going to do is incorporate all the facts that they've just set forth in these causes of action. That's why the first paragraph in each cause of action will say this: plaintiffs incorporate the foregoing allegations as though fully set forth herein. We're not going to reset forth everything we just did in the first cause of action. We're just going to refer to them here and say, we're going to incorporate all those allegations here. So the first cause of action is the Utah RICO, which is why they talked about the co-defendants organizing and creating an enterprise. That conspiracy, right? That's why I said, I bet they really wanted to say conspiracy instead of enterprise.
Yeah.
And then they're just going to say, based on those facts and taking the relevant facts from above and putting them in here, this is why we think that we've got a cause of action here, and we're alleging it against them. Let me just give you an example of this, okay? In this first cause of action. Saying alleging they created the enterprise as a group of individuals associated, in fact, for the common purpose of conducting the pattern of unlawful activity described herein. They acted intentionally, maliciously. They have to set forth the words that matches the law they're claiming the co-defendants violated. And so they're saying that there is a RICO statute that's conspiracy. And here's the different ways they're saying it was done. All of these, none of this is new facts, and it's going to be highly, not only is it going to be duplicative of everything we've gone through, which itself was duplicative, but they will be duplicative of each other. The same facts will be used to support different causes of action. So there it has all these other things. See, look, permanently closed. We stole a family's life savings. They sued. We lost. They're incorporating all the facts that they've set forth above, or at least all the alleged facts that they've set forth above. And then they go on to this. This is all this huge first cause of action under the Utah RICO statute, obstruction of justice. Now, interesting. This is actually not supposed to happen, where in their cause of action, they allege facts that they didn't allege before. But it appears that here they've done that. It's similar to what we've heard before, but different. They're talking about obstruction of justice, such as Schneider, they're alleging, when Schneider described on video as a switcheroo. Remember that guy who was dressed like him?
Yes, yes.
A switcheroo. We haven't heard switcheroo before. We should have heard it
No.
before. Designed so that once the police find out they caught the wrong bin, I'm going to be super far away. We haven't heard that quote before. That should have been in the facts alleged. So once again, it's very long. It's almost 100 pages. I know it's impossible to get things perfect, but this is pretty obvious, even to a small town lawyer like me who's reading this for the first time, that this should be up there as well if you're going to cite to it here. Okay. Wow. You actually have to prove a lot of things to show RICO, and that's why it's so long here.
Yeah. That section was really long, that one.
Look at that. That's all that. Here's the second
Wow.
cause of action now. Defamation per se against co-defendants.
Okay.
That's the allegation. Defamation per se, remember, crimes.
Yep.
So that's the defamation per se, steal from old people, actively working with the thieves, correctly spelled, to cover up the matter. I'm never going to live that one down.
I don't think you will. We better figure out how to redact it. Yikes.
It's okay. I need humbling from time to time.
Every once in a while.
Okay, so there's that.
So these 10 things that we're kind of scrolling through are just showing these are what this is the element that they're suing over.
These are the allegations.
Right,
They're
the
making
allegations,
causes of
right.
action. The law gives certain
Right.
causes of action to people
Right.
under certain circumstances, such as defamation. That's a cause of action.
We've got
Why? Because it's
RICO,
in the law book.
defamation, and now we've got
That one was defamation per se. The second one.
this is
This
just
is
plain
just
old.
defamation.
Okay.
So they're going to allege they said things other than defamation per se
Okay.
that constitute defamation.
And does everybody, those 15 people that they even haven't identified yet, are they all being charged with everything, or is it going to kind of, these people did this, these people did that? I mean,
Well, right now they're trying to allege a conspiracy, which they're calling an
So
enterprise.
the whole group, the whole
To
team.
the extent that other people are involved, if they are part of a conspiracy, then they would be on the hook as well.
Okay.
That can all be proven.
That makes sense.
So it's not easy to prove, but especially if it's not true. But we'll have to see what happens. Fourth cause of action: injurious falsehood, trade disparagement, and false light against co-defendants. They put their company in a false light. Bam! They have disparaged their trade. They have said falsehoods that were injurious to them. We've read about that. And they will be recapitulated here. All the different things they're alleging that fall under that cause of action. Fifth cause of action: civil conspiracy against co-defendants. And there's overlap a lot of times between the different causes of action. So they're saying a civil conspiracy amongst the co-defendants. It sounds a lot like the RICO statute, and we'll have overlap with it. Sixth cause of action: tortious interference with existing and prospective economic relations. They're alleging that against the co-defendants. So in other words, you're screwing with our business, both in the present and in the future. And they'll say that in a little bit lengthier terms here in these paragraphs. Seventh cause of action: civil stalking against Schneider and Schneider Group. Once again, it's a little confusing because it's civil stalking is the seventh cause of action. They're making that claim against Schneider and the Schneider Group. The way they're writing it in the title, in the parentheses, it sounds like the civil stalking was against Schneider and the Schneider Group.
Okay.
But that's not what they mean. This could be clearer. It's civil stalking, and it's alleged against Schneider and the Schneider Group. as opposed to necessarily any of the other co-defendants. They're carving Schneider and the Schneider Group. Well, that is all the co-defendants, really, the way they've alleged it. So it is everybody. And so they're saying civil stalking. Was it stalking there? I think it was civil stalking. There's a civil statute as well as a criminal statute for stalking. Nuisance against co-defendants. And by the way, in case everybody doesn't know, in a civil suit, you can't bring a criminal charge. Criminal charges are brought by prosecutors after police investigate and refer to the prosecutor's office. The prosecutor makes a charging decision. That's a criminal charge. A civil attorney in a civil case doesn't have the power to bring a criminal charge. That is reserved to the state. And that makes sense. That's the general rule. There are exceptions. I'm not going to go into the exceptions now. The eighth cause of action is nuisance against co-defendants, because nuisance can be something that is actionable if you're a nuisance to somebody else by your actions. So they're saying that what they did also constituted a nuisance. It was also trespass, which they're alleging against Schneider and the Schneider Group. We've heard their facts for that. They'll recapitulate them here. 10th cause of action, intentional infliction of emotional distress against co-defendants. Once again, that's the action against the co-defendants, which they're claiming amounts to intentional infliction of emotional distress. Once again, same allegations. We see them, the Frenchies email. 11th cause of action. This officially now has as many causes of action as Ben-Hur won Academy Awards.
I thought it only had 10. Are there really 11? Oh my goodness.
It says 11th.
Oh.
Unjust enrichment, accounting, and disgorgement of profits by all co-defendants. So they're saying you have unjustly enriched yourself by doing all this crap. You've made money off of it. And we want an accounting of that. And we want the court to order you to give back all those riches that you have unjustly obtained. That's the disgorgement of the profits that they're asking for by all co-defendants. As a general proposition, if you were to get money wrongfully by violating the law, then you can ask the court as part of a lawsuit to make them pay it back or give it somewhere. You know, they shouldn't be able to lose a lawsuit but still have profited by their wrongdoing. So that's why this is put in a lawsuit. That's a general they. I'm not making any decisions on this lawsuit. 12th cause of action, declaratory relief. And now declaratory relief usually means asking for something to be done before the trial. I think that's what they're asking for as an injunction at this point. Let's see. Plaintiffs requested are entitled to declaratory relief respecting aspects of the private legal dispute between Crystal and Brian, including inter alia, among other things, determinations that BAM and Salem Baker acquired rights in and to the assets of Salem LLC lawfully and in accordance with governing contracts and applicable laws. Plaintiffs are neither parties to nor have any contractual duty or obligation regarding the alleged 1122-23 consignment agreement, and see regarding such other legal determinations as may be requested during the rights of plaintiffs under the circumstances. Okay. Yes, that's what this is. What they're asking the judge to do is to decide these issues before a jury. I mean, without a jury, prior to that. I'm not sure that makes any sense. Okay, let's put it this way. If there's a jury that is called in and there are 10 things, 10 prongs, 10 component parts that they have to find happened in order to render a judgment or make a decision on, and you can tell there's at least 10 things here, right? It is possible that if the parties agree and if there's no dispute to a certain fact, that they can present it to the judge and the judge can say, okay, that's an agreed fact. The jury doesn't have to decide that. It's already been decided by agreement of the parties because there's no dispute on the facts. Juries are there to resolve disputes between the parties. Makes sense, right? If the parties agree on something that's part of the overall case, then that can be entered in the record by the judge signing it, and it never goes to the jury because you don't need the jury for agreed facts. I really doubt that any of these fall under that category, though, because these seem to be very dispositive and things that the other side will not agree to.
Right.
It would, I would expect the judge would say, yeah, we're going to let the jury decide this one.
Oh, yeah, no, they're going to have to, because almost everything here, as we see in the chat, everyone can say, nope, watch this video. Nope, look at this timestamp. Nope, look, it's just going to have to come out.
And the other thing is, it doesn't even have to be that developed. Okay, just for what I'm talking about. The other side that I don't agree with that. Boom, you don't get declared.
Okay, yeah, I'm sure that's what will happen.
Okay, otherwise you don't need a jury for that.
Okay.
So 13th cause of injunction, injunctive relief. Here we go. There's the injunction I thought was coming. So they did all this bad stuff. Co-defendants' ongoing and threatened conduct constitutes a continuing course of misconduct, harassment, etc. Monetary damages alone. Remember that line? That's when I started talking about injunctions when we encountered it before.
Yeah, you said that was coming.
Cannot remedy bomb, death, and other threats, etc., etc. Plaintiffs are entitled to the immediate entry of a temporary restraining order. That's the injunctive relief. And preliminary and permanent injunctive relief against co-defendants, their affiliates, employees, contractors, blah, 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 restraining them from doing any of this stuff that we're complaining about. So we'll see if that happens. That will also happen at a future hearing after the defendants have had a chance to file their response and their objection to a temporary restraining order, or any restraining order, I'm sure. And the judge will have to make a decision on that before the trial. There'll be a decision made early on. So here's all the things that they're asking the judge to order that the co-defendants not do as part of the injunctive relief. Preservation demand, once again, that's preserving the evidence. So they want the co-defendants to preserve and retain all evidence relating to the matters described herein. Don't go destroying stuff. Election of discovery tier. They have different tiers. So how you do the discovery between the parties. Tier 3 discovery. This is Utah stuff. So I'm not aware of any tiers in Washington, but they have different kinds of discovery based upon the amount alleged. And I'm guessing that for greater amounts, you're going to have more detailed discovery, and for lesser amounts, you're going to have less detailed discovery, and that's what the tiers involve. Prayer for relief. And here's where, once again, they say the same thing they've said before, but it's under the prayer for relief. This is actually a 6th section of the complaint. I forgot about the prayer for relief. Wherefore, plaintiffs respectfully request that you do everything that we've asked you to. And that's what all that says. And do you want to read this? I think people might be interested.
Relief?
Yeah.
Are you sure?
Well, here, hang on a second here.
You just don't want to paraphrase it? Like tell people what a prayer for relief is?
Well, it depends on the case, but what they're saying is this is the stuff that we want you to do, Judge, on our behalf. By the way, the prayer for relief, if the other side does not respond, of course they're going to respond. If the other side did not respond to this and they were served, then the judge, as a default judgment, would grant everything that the plaintiffs are asking for in their prayer for relief. So for that reason alone, it's very important. And also, generally, you can't get anything more than what you ask for.
Oh, interesting. So this is everything that they want. Okay.
Yes.
Let me see. The prayer for relief. What happened?
Sorry, I did that.
Wherefore, plaintiffs respectively request, number 1, that a judgment be entered in their favor and against co-defendants jointly and severally as each case of action. Number 2, this injunction relief to be entered, including a temporary restraining order, preliminary injunction, and permanent injunction prohibiting co-defendants and anyone acting in concert with him from A, making, transmitting, soliciting, encouraging, or felicitating death threats or facilitating, death, bomb, or other threats, thief, of physical harm, property destruction, or otherwise. Again, my dog started barking. You guys can probably all hear it. I know. Or otherwise against plaintiffs, their franchises, employees, officers, owners, customers, vendors, or family members. B, publishing or encouraging others to publish home addresses. Yeah, that's a big one. Personal phone numbers, personal email addresses, family information, or other doxing information of any kind regarding plaintiffs, personnel, franchisees, owners, or employees. Number 3, entering, remaining at, filming, blocking access to, or approaching within a defined distance, not less than 1,000 yards, plaintiff stores, offices, warehouses, franchise locations, parking areas, employer homes, or franchisee homes after notice, except through counsel, lawful service of process, or court-appointed activity. D, impersonative plaintiffs, other franchisees, law enforcement, or court officer, a delivery service, a customer, a government entity, or any third party, like an Avon lady or something, or a missionary, right?
Or
To obtain,
USPS worker.
to obtain signatures, access statements, employee information, customer information, or business disruption. E, touching, altering, covering, defacing, or placing signage of any form or any form of communication, i.e., electronic, social media, affecting plaintiff's property, including signs, falsely stating or implying that plaintiff stole from elderly persons, stole life savings, lost in court, or closed to avoid paying a judgment. F, blocking, deterring, or interfering with customers, employees, vendors, or delivery personnel doing business with plaintiffs in any way, including entering or leaving of any of plaintiff's locations. G, soliciting plaintiffs, employees, franchisees, or contractors to act as undercover agents, leak confidential information, record inside stores without authorization, obtain phone numbers or private information, create or participate in staged confrontations, or otherwise engage in any deceptive activity relating to plaintiffs and their business or personal interests. And H, using fabricated, deceptive, or misrepresented contracts, raffles, lotteries, court papers, awards, and other programs, instruments, recordings, or documents to deceive, manufacture evidence, or create staged confrontations, deter personnel from calling police, or manufacture claims of criminal or other misconduct. Whew, I
This
feel
is
like I
where they're
just
asking.
summarized the whole 90 pages there in what they're saying. Please stop this.
Yeah. So basically, here they're saying what we want you to do is to make it so they can't do any of the things that we have
Right.
complained about, plus anything else we could
That's it.
conceivably think of that they might do.
Yep, that's it. Wow, that was a mouthful. That's for sure. Do we need to finish reading it? The
Oh my God. Let me
declaratory.
just check this. Yes, we do. It's not too
Okay.
far. We can do this.
All right.
By which
Okay.
I mean, you can do
The
this.
declaratory relief and a judgment relating thereto be entered or requested, and inter alia, right? Declaring that number one, plaintiffs have acquired rights in and to the assets of Salem LLC lawfully and in accordance with governing contracts and applicable laws. B, plaintiffs are neither party to nor have any contractual duty or obligation regarding the alleged 11/23/22/23 consignment agreement and regarding such other legal determinations as may be requested concerning the rights of the plaintiffs under the circumstances. So basically say we didn't do anything that you're claiming that we did.
Right. Rule for us.
Yeah, rule for us. That's it. You can read the rest. We'll
An actual, general, consequential, compensatory, special, statutory, exemplary, and or punitive damages be awarded to plaintiffs. You can't get it if you don't ask for it, so you ask for everything.
Mm-hmm.
And against co-defendants in an amount to be determined at trial, that pre- and post-judgment interest on all damages be awarded to plaintiffs and against co-defendants is allowed by law. You want to get interest on those judgments. That cost of litigation, including attorney's fees, expert fees, and taxable costs, be awarded to plaintiffs and against co-defendants as permitted by law and or contract. I'm doing that because I'm thinking about contract. I'm thinking, well, there may have been something about that in the contract with the people who owned the prior store in Oregon.
Oh, yeah.
Yeah, there wouldn't be a contract with relationship to reckless Ben. For such other and further relief as this court deems reasonable, equitable, and just. Okay, attorney's fees can be awarded if it's provided for in a contract or if it's provided for in the law. And usually it's not. It's rare circumstances that attorney's fees for the prevailing party are permitted, but they are in certain cases. And if they were in this case, I don't know. I think they might have cited to something. And here's the verification from Ammon McNeff, who says, I've read all of this stuff and verify that the foregoing allegations are true and correct to the best of my knowledge, information, and belief. So there's the verification. Ammon McNeff is swearing that that is correct. Yeah, all those facts that we've read to are correct. Obviously, the ones that he would have knowledge of, but you still. And here's Josh Johnson. doing the same thing.
Hmm.
He is verifying this complaint and verifying that the foregoing allegations are true and correct to the best of my knowledge, information, belief. It's an important part to have there because these are the guys who are providing the facts.
Right.
Otherwise, you just got an attorney who's saying what somebody else told them. It's very important to have the people who told him on record as verifying that they're saying that this is true. So if it's not, and if there's proof to the contrary, then you know who it is who's not telling the truth, right? It's not necessarily the lawyer. It's Ammon McNeff and Josh Johnson.
There it is.
And there's the signature of William Kelly Nash, who's signing off for these three attorneys from Denton's, Durham, Jones, Peiniger, PC. And I think that is it.
Oh my gosh, I can't believe it. So answer me this. Are any of these people facing jail time, or
No.
is it all monetary?
Nobody is.
They'd have to repay and all that. Okay. Yeah.
There's no jail time in civil court.
Okay. That's
Page
what
95, like 95.
Yeah. Although you said RICO was more, isn't criminal.
Civil RICO.
Civil RICO. Okay. That's the difference. So,
yeah.
Okay.
And RICO can be criminal, but so can stalking.
Whoa.
But it can also be
Fall
civil.
off my couch here. Well, there it is. We did it.
Yes, we did. Oh, by the way, just as an example for that, OJ, rest his soul.
OJ.
Remember that he was tried criminally for murder and
Yes.
acquitted.
Yes.
And then he was tried for the same conduct civilly.
Yeah. No, do you
And
know
he
that
lost.
this reminds me, and he lost. This like I said, a summer, something that's happening. It reminds me how everyone was just so fixated on OJ, staring at the TV, the low speed chase, everything, for some reason, this, people going through the details, it reminds me of that era somehow.
Well, I'll tell you, it is only because of the interest that you have told me that people have in this that I went and got the complaint when I heard it was filed. And once again, it was through the good graces of my attorney friend in Salt Lake City who sent it to me. He obtained it and sent it to me. And that we have now spent 4 hours and 16 minutes.
I think this is the longest podcast I've ever done. But, it's interesting because I have heard people weigh in and say, BAM just shouldn't have done it. They should have just, not what they're accused of doing, but they should have just somehow made the Lego owners whole and said, whatever, it's a wash. Because when you're going up against a social media influencer, this can happen, right? This can happen. And I compare that to a John DeLynn scenario when the LDS Church goes up against, John DeLynn, the suits, use the word Mormon. This happens, right? Everybody talks about it, the Streisand effect. So I don't know. What are your thoughts on that? Should they just have somehow made everybody whole and said, we're not going to file a suit? The suit just gives everybody continued content, right?
Mm-hmm.
We can talk about it more
and we will,
and
by the
more.
Way, I want to say that, now that I'm in this far, I'm not going to become a private investigator on the case. That's not what I'm going to do. But I will definitely go over as thoroughly as we did here the response from the defendants, okay? Once they file those, we'll certainly go over those because we want to have both sides have their say. I think that, it depends upon your perspective. If you're just looking at it pragmatically, and if you know the future, which is tough, even in Mormonism, there aren't a lot of people who know the future and can see around corners. But you could predict something bad could happen. But on the other hand, if you are BAM and you're genuinely innocent, okay, and it was these ragtag people that you sold or you gave a franchise to, sold a franchise to, and then they bombed out like they say happened. And then those people were involved in some guy's consignment, which you never benefited from, never knew about, never authorized. Then, why would you want to bend over and pay $60,000, $80,000, $200,000, whatever it is, for something you genuinely did not? And there, the idea of principle comes into play. And the idea of, if we do this, then are we going to have to pay off anybody else who does this or makes claims that not only are they saying are unfounded, but not true? On the other hand, I don't know. On the other hand, from their point of view, from the co-defendant's point of view, no, let me go back to the plaintiff's point of view. If you think that you are guilty, all right, you might still do it. It would be better just to pay it off. You're right. Pay off the $80,000 if you think that you're guilty. But then again, I don't know what's going on. People who are guilty will challenge it with their last breath in court. Just because you bring a lawsuit doesn't mean you're innocent, is all I'm saying. It
Exactly.
doesn't
And
mean
what
you're
would have
guilty.
happened? What would have happened if, this all went down and then BAM said, you know what, we can't determine what happened. We don't know what's happening with our franchise, but out of the goodness of our corporate heart, we would like to award this gentleman $200,000. And, we've purchased his Legos from him. There you go. Big check. I mean, it would be a whole different scenario, right? It would be good PR.
Yes.
It wouldn't be really admitting any guilt. It would just say, we don't know. We're trying to sort this out. Let's make this gentleman whole. None of this would have happened. They would have been the good guys. But you're right. It's hard to do that if you believe that you're innocent.
I think what all
I
this
don't
boils
know.
down to is Josh Johnson. Because what BAM is doing, he's the guy who knows, right? And that other guy who's with him, but mainly Josh Johnson. Was it Brandon was the other guy who went into that franchise after the other people were kicked out or left or escorted from the premises or whatever it was, right?
Right.
This all depends upon him. Because BAM at corporate in Utah has no idea what was going on the ground at that store when they took over. And nobody was with Josh or Brandon when they went back into the back room the first time to see if any of those Lego sets that Brian was complaining about were there.
Yep.
And they weren't there when substantially later, I think it was months later, they went back again to check and suddenly they find 20 Lego sets, which they believe do belong to him. And what's going on there? Yeah, they're backing their boy. The company is backing Josh Johnson.
And yet, as I understand it, he's been let go along with Brandon.
Really?
Yeah. So that's what I'm saying. There's
Josh Johnson has not only been released as a high councilman, but also
allegedly, yeah. And I will say, a lot of people in the chat are saying the Mormon connection. Let's discuss this. That we were not going to discuss anything like that because it was just simply reading the suit with a lawyer, right? But exactly. But I will say at 4:30, everybody knows probably John DeLynn, Julia. She's been working on this nonstop. She has got such good information. And they're going to dive into all of the nuance of everything, right? We just took this one little piece to read it into the record, the lawsuit. And again, I'll say, if you've joined us late, this is not our opinion. We are reading a lawsuit. The pictures that you saw, we did not gather them. We are reading a lawsuit just to read it into the record. So let's all, if we can, take a bathroom break and then come back for Mormon stories at 4:30, so that we can watch this because there's so much to it. It's brain boggling.
And I have no idea what they have or what they're going to show on the Mormon Story Show. But if they show anything, and if you watch this and can watch that, then you'll have the chance to compare what they're saying or showing, if you don't know it already, with what it is that BAM is saying.
Yes.
And if there are places where there's contradictions, now you'll be able to see that.
Exactly. That's it. Because they're not going to read through the suit. I'm sure that's not what they're going to do. They'll probably mention the suit has come out, but I doubt they'll read through the entire thing unless they want to go 12 hours. But you're right. What they present, everyone having just watched this will go, oh my gosh, I forgot about this part because that counters that. Yeah, it's just like a huge puzzle, which is why everybody's so intrigued. So, well, thank you for doing this, RFM, because when I knew that you had the suit, I was like, should we do this? I think we should do this. I think it would be useful and interesting to people. So, both of us canceled other things to do it, didn't we? Because we felt this was really important.
Yes. The thing was that you had asked me by text this morning.
Yeah.
I think it was who were the attorneys who were representing.
That's how it started. I wondered if it was Curtin McConkie. I did.
And so I was able to finesse, as I've said, a copy of it really quite quickly. And I'm very thankful for that to my friend in Salt Lake. But and then we started talking and oh my gosh, because I have been working very hard on this interview, which I was going to do this morning. It was scheduled for.
And I had an interview too this morning. Yeah, both of us had other people. Thank you to the other people that moved away from, when I said, I am so sorry, I'm canceling this like half an hour before because this has come up. So thank you.
And I did that. I rescheduled it for a week.
Yeah.
So that was going to be an interview that was going to be recorded and then premiered tomorrow night, Saturday on RFM. But now there will be nothing on RFM Saturday because we did the special pop-up newscast live
Yeah.
on Friday morning. So my apologies to everybody out there who is very disappointed at that news. However, Mormonism After Dark will be going live tonight at 8:00 p.m. Mountain Time, which means 6 hours from now.
I know, like I said, you gotta go, I don't know, bathroom break, go to the gym, get something to eat, come back.
I think I'm gonna do that right now because
Yeah,
I
I
haven't
think
had
we both are.
anything to eat yet, and, I'm
No, me
starting to
neither.
get hungry. There's a rumbly in my tumbly.
I agree with that. All right, sign us off, RFM. This was your show.
Wow, everybody, thanks so much for joining us. If any of you stayed on from beginning to end, you get a special award. And, please join us next time. I have no idea when the next pop-up will occur because that's why they call them pop-ups, but it's not I doubt it's gonna be any time in the next week or 2 because can you imagine having to file a response to all
Oh,
that?
yeah,
In situations like this, it's even possible for defendants to ask the court for, an extension. Can
right.
we look, this is a ton of stuff, and can we get another 20 days or whatever? Usually the judge will grant that kind of thing if you ask for it in situations like this where, yeah, it's going to take a lot of work and a lot of time. So we'll see if that happens. And my commitment is, though, that once responses are filed, that I will read them, and hopefully you'll join me,
Yep,
Rebecca. But my commitment is I'll go over them on the air
yep,
as thoroughly and word for word as I did the original complaint.
yep,
Plus, it'll make a lot more sense now to read the response. Can you imagine reading the response without reading the complaint?
yeah. No, and I was curious to see what they had, and now I'm even more kind of scratching my head. So
Mm,
we'll have to see.
yeah. All right. So thank you so much, everybody. We'll see you later. Thanks for watching the Mormon Newscast. We'll be on for our regularly scheduled episode next Monday at 6:00 p.m. Mountain Time. And I may or may not be there. We'll see. If I do, I'll be broadcasting from a remote location in
Ooh.
upstate New York.
Oh my God. Well, Bill and I will be there for sure, and RFM may be in a bunker, which is always exciting when somebody's remote. So
Or in
tune
a
in to
grove,
see.
a bunker or a grove, perhaps.
Woohoo. Oh my gosh, if you could do the newscast from the Sacred Grove, that would be incredible.
It would be awesome. I've got a feeling it's gonna be getting dark out there by that time, but we'll see, okay?
No,
And the
no,
mosquitoes are murdered
flashlight, just like this.
like a flashlight,
Yeah.
except you do it from top to bottom so that
Well, it
two
is a
beings can
Sacred
descend
Grove.
in it,
Yeah,
right?
you'd have to
Yes.
be going like that. So
All right, I'm gonna get out of here now.
me too.
Thanks
Gotta
again,
go. Thanks,
Rebecca. Thanks,
everybody.
everybody, for
Bye-bye.
watching. We'll see you next time. Good night or goodbye.
That's a wrap for this week's edition of the Mormon Newscast. We appreciate you tuning in and sharing this time with us. Keep the conversation going and stay informed on all things Mormonism. Until next week, wishing you peace and joy. See you next Monday at 6 p.m. on the Mormon Newscast.